Yes. Obliged. Subject to move lunch motion, Your Worship.
May I permit to move lunch motion regarding the elections are the new enrollment and objections are last date for today, my lord. Yesterday filed and number also, my lord, main number.
Tuesday, nothing is happening. We are not going to stay the election.
Not to staying for the election, my lord. My lord, my humble submission is kindly here, my lord. They have to verify and check the absence shift
Tuesday,
and
Tuesday.
Lord, already some today is last day, my lord. And moreover, my lord, the election.
So why have you come last day?
Yesterday only filed, my lord.
Why did you come?
Not main number also.
What is the urgency? You are not being permitted to vote. Polling will take place on 30th November.
No, not. I am the contender from the Indian National Congress Party. So I submit objections more than 1 lakh. So they have to mention on the electoral as absence, shift, death and
That will be done. We will not.
time will not permit. One humble submission. Lord. Today is last date for no enrollment. They will publish the enrollment electoral on 15th. Lord. So, Lord, kindly permit to our main number. Lord, kindly
14th. Yes.
Lord, kindly. Otherwise, time will not permit. And the election access will say, please not sufficient for us. Lord. Kindly, my humble submission. Please, Lord. Please, kindly.
No, we should publish the list today itself for you, right? High Court will publish the list.
Not High Court, Lord. Sorry, Lord. That is not my intention.
What?
Once the date is given, you don't go on mentioning. Once the date is given,
Nothing will happen. He is not being hanged, we are sure. He will be alive till 30th November. It is not that he is being hanged today at 2:15. So you are saying that in case it is not heard, he will be dead and gone.
Not like that, my Lord. My humble prayer is kindly, Lord. Time is not permit to go, Lord. Second of verify as the action shift and duplicate, but it is my humble submission.
List is not there. Yesterday I had made notes. PLN. Yes.
Lord, it is already main number also, Lord. Main number also I got, Lord. 3144. Kindly consider, Lord. Kindly, my humble submission, please.
You have not been able to tell us what is the urgency, what will happen if it is not heard today, and what will happen if it is heard on 14th.
Yes, Lord.
What is the irreparable injury which can't be set right by this court?
Yes, Lord.
For this you are saying everything else.
Yeah, Lord. The urgency is today is the last date for no enrollment. For submit of Form 6 applications.
Yes,
So total
yes, madam. PLN. Call him. Where is the list? Yes. No. Huh? I have made notes on this. No.
subject to move.
Lord, my opponent parties are submitting bulk of applications. When today is last day, the inquiry and publication of amendment electoral is 15th, Lord. That is my urgency, Lord. I have put my election 3 times since from 2009, 15 and 18 also. So the returning officer or the enrollment officer will make an absent shift.
What there is no urgency. It will be if additional names have been, we can direct deletion.
Not kindly give lunch motion. Kindly grant lunch motion.
Yeah, what interim order do you want, Mr.?
No, already we approached it.
What interim order? Your apprehension is that some names of some voters will be added who are not residents of that area, right? Or whatever.
Yes, ma'am. On the role of the electoral documents, they will mention AFD, that means option, shift, death and duplicate. So on the date of 30th November, polling agents will mention AFD. So the particular candidate cannot be able to vote.
They will vote only on 30th November. Before that, we will hear your case on 14th November.
Yes, my lord. Then, my lord, my humble prayer is,
Right.
we will not permit to the election officers, my lord. They will publish the amendment on 15th. Today, last day.
We are taking up the case on 14th, Mr.
Obliged.
You don't understand this. We told repeatedly 14th we are taking up.
Obliged, my lord. Obliged. If any comes, my sincere apologies.
Subject to move lunch motion, Your Lordship.
What urgency, Mr.
Your Lordship, the petitioner is a
The court is not closing forever. It's only Monday is a holiday, Saturday, Sunday as usual. We will open on Tuesday. What is happening? Your house is being demolished. You are being hanged to death. What is being done?
petitioner is a registered political party, Your Lordship, namely Praja Shanti Party. They are
What is-
contesting in 119.
No, so what is happening? They are being prevented
Your Lordship,
contesting or this thing campaigning.
Election Commission.
What is happening?
Election Commission of India has not allotted a common symbol to the petitioner, Your Lordship. And today is the last date, Your Lordship.
14th.
And Your Lordship, the
15th.
Your Honor, may I be permitted for 30 seconds, sir? I
No, no,
personally,
who is he? Then you sit down, mister. He doesn't have faith in you. Then sit down. That's why he is addressing the court.
no,
Sit
Your
down. He's
no,
your
Your Honor.
counsel.
Yes, sir.
Then have faith in him. When
No,
he is
I have faith in him,
asked,
sir.
then sit down.
Because
mister.
I
We will
feel
not.
yes.
Persons cannot do like this. We can't keep this thing. We cannot permit a party in person. Either you appear in party in person. You sit down, mister. You withdraw your wakalatnama. Let him argue.
Continues because today is
No,
the
no,
last date, Your Honor,
No.
to file 199.
We will not take cognizance of what you are saying. So long as counsel is appearing. Either let him appear or you appear. Choice is yours. Then please sit down, relax.
I apologize,
Yes.
Your Lordship. Your Lordship, in petitioner party is contesting a 119 listed constituents, Your Lordship. And Your Lordship, today is the last date for filing nominations, Your Lordship. And on 13 is the scrutiny of applications, Your Lordship. Your Lordship.
So you are not being permitted to file nomination.
Yes, sir.
How can anybody prevent?
In the name of-
Who is not being permitted? Which person?
In the name of common symbol, we cannot file, Your Lordship. Your Lordship, nominations are, Election Commission of India has not filed, issued a symbol, Your Lordship, allotment of symbol, Your Lordship.
When it was
Unless
not,
the symbol-
1 minute, when it was not allotted to you?
Your Lordship,
When?
Your Lordship,
When it was not,
Where is your
when, just a minute. We want to know what are like 11th hour, you are rushing to this court. When this thing election symbol was not allotted to you? How can it be that election symbol is not allotted? How can it be?
May I please, my lord?
What is this? Who, you are a counsel?
No, I am assistant to my
No. What is this? You are the counsel, right?
No, my
Then
lord.
how are you addressing this court? What capacity? He is telling us, we are asking, see, mister, you want us to pass an interim order the way you want without asking the questions, right? We are just asking him when was the election symbol not allotted to you? Allotted to you. It can't be like this.
Your Lordship, we have submitted application seeking
When?
on July of this year, July month, Your Lordship. But
So what were you doing from July till 10th of November?
yes, Your Lordship. After that also,
What have you done?
we have filed two representations, Your Lordship.
Nothing. A representation we will consider on 14th
Your Lordship,
November. Yes. Next.
Your Lordship,
14th November. Yes.
May I make a mention?
Ah,
The WP bill 65 of 2022, Mulad, it was.
no urgency in film, mister. Nothing is,
No, no,
it doesn't belong to you.
Pleadings are
And
complete, Mulad, the.
file an application for urgent hearing. It must be with regard to government property, right? Government land.
Yes.
Yeah. See,
Mulad, it.
How do we know? what is like, it will not, even if bill is allowed, the land will not be allotted to you, mister.
They filed the bill under the guise that the graves are being encroached, Mulad. It's a private land. Government also.
You file an application, which year it is filed?
22.
Ah, So you want
I
its final
experienced
hearing.
unofficial respondent.
You want the final hearing, right?
Yes, my lord, pleadings are complete.
Huh?
It was supposed to be listed on 5th
Tell him.
September.
If there is an urgency, please file an application for early hearing.
I
Don't ask out of order.
We don't this thing do it. Yes.
For item 41, Lord, permit to withdraw. Lord.
You are the appellant.
Yes,
Appellant, right?
yes, Lord, petition.
41. Learned counsel for the Mr. Write his name. No, this can't be Mr. Dunn.
I been yesterday, because I am the patient. Next. I am the president of the party, Your Honor.
Fine.
Today is the last day for 119, 1 minute, Your Honor. 119.
No, please don't interrupt. Mr. Two counsels have addressed us on your behalf. This cannot go on. We have passed an order. The remedy is to go to Supreme Court. This is the only thing you can do.
Today is the last date, Your Honor.
We will, in case this thing it is found, we will see what can be done.
No, 2 days left. Today is the last day for 119 candidates, Your Honor. They are promising since October 23rd. Tomorrow symbol is coming. I personally met the Chief Election Commissioner, Your Honor. He assured me, Deputy Election Commissioner assured me. Yesterday I was in Delhi. Honorable 2 ministers have requested them because I am chosen for 68% of the vote.
So since July you have been waiting, wait till 4th
No,
July.
until October 23rd, they did not issue us, Your Honor.
So what did you do on 24th November? 24th October? Why this is, so we are not here to convince you, Mr. And don't, this is a court hall. Don't compel us to take some coercive action against you. Right? Yes.
This is the last day, Your Honor.
Yes.
Having regards to the facts and circumstances of the case, submissions made by the learned counsel on either side and also taking into consideration the aforementioned judicial pronouncement into consideration, we are of the considered opinion that the respondent authorities have totally misdirected themselves and issuance of GOMS 32 dated 12/9/2026 is manifestly erroneous and therefore the GOMS 32 dated 12/9/2006 is liable to be quashed in its entirety and accordingly quashed. Consequently, the impugned common order dated 31/12/2008 passed by the learned single judge allowing the writ petition in part is liable to be set aside and accordingly the same is set aside. In the result, the appeals preferred by the petitioner appellants allottees, that is WA 43, 120, 121, 181, 182, 183, 474 and 525 of 2009 are allowed and consequently the appeals preferred by the state, that is WA 131, 139, 367 and 372 of 2009 are dismissed. Direction is issued to the government and the housing board authorities to act upon the earlier GOMS 2 dated 10/1/1991 and after collecting the difference of amount from the petitioner, allottees shall register the plots in terms of the original allotment letters issued on 4/6/1991 within a period of 4 months from the date of receipt of the copy of this order.
Huh? List before a bench in which one of us. Okay. Issue notice of IA 1 of 23.
I have filed a caveat earlier, my lord, and
Delay in representation is condoned. things to do to hear the commercial appeal of 23.
Yes.
We have litigants waiting before us since 2005, 6, 7, 8.
I know, I'm conscious
Yes.
of that, my lord.
Yes.
Some date at least after 4 weeks. I leave it to lordship. At least 4 weeks, a date may be given.
Once you file, what is the date? I mean, once you file counter, it will come up. Or you file an application for vacate stay. Ask your colleague to make a mention. What is this? This why it should be heard, Mister. This appeal because you are appealing. Therefore, we should 23 appeal should be heard. Finally, we can't do this. Sorry. Heard on IA 1 of 23. That's the usual order which we pass. Same order. On the delay control IA is allowed. Deposit.
Right.
But is it not premature that he may not be put deposit? Then
Right.
at this, in anticipation, we have not consulted any astrologer that he is going to deposit on this date. How can we? You tell us when he will deposit the amount. We are giving you time.
Right.
Please file counter, whatever, when he deposits, file an application, we will allow it.
Right.
We grant code slips every day, mister. What is mention memos? Once you file counter, please file a mention memo, get it listed. Notice on IA, one of
In spite of that, my claim petition was rejected.
that's why we are issuing notice. What, you are appearing with him or against him?
Your lordships, I have filed caveat for the respondent number 1, my lord, but the caveat is not reflecting in the cause list.
Notice on behalf of our
Third copy, sir. Already a third copy, sir. Gave it.
copy. So and so has entered appearance. Record. Yes.
Appellant Palata is the owner of the vehicle.
Well, why don't you file an application under section 451?
Application expired. My submission is Palata, we have also sought from the consequential prayer of one awarding damages. Because admittedly, the vehicle was seen on 3/2/20.
Damages, Mr. In the writ petition, please examine the judgment decision of the Supreme Court. What is it? Damages can be granted for violation of fundamental right. And we don't have any means to quantify damages. That is another thing. We can award you 5,000, 1 rupee, 10 rupee because we don't record evidence. What is it? This is in a way yes, one more thing. Why the claim for damages in a writ petition? Because it is not a fundamental right. It is a constitutional right under Article 300A. File a suit, claim damages, nobody prevents. What do you do? The order is correct, we are not inclined to interfere.
The purpose of not asking the damages only.
All right. In this writ petition under Article 220, where is Notice on IA 1 of 23 and 2 of 2023, list along with WN.
I'm obliged. There is a delay of 60 days in the representation.
Yes. So what is the relief sought in the appeal?
The relief is sought for
Cancellation of sale deed.
really.
Can we do it? What does SP Anand say? Supreme Court.
Please, ma'am.
Know it, right?
Please. The learned single judge said go to the competent civil court.
Correctly so. This is what SP Anand Supreme Court has said, that in an article under Article 2, in a writ petition under Article 226, we cannot cancel a instrument.
But whereas, as far as the limitation point is concerned, that has to be condoned, madam.
Okay.
Before filing the competent civil court, a civil suit, madam.
We can't.
Because I have availed the opportunity of filing writ petition.
Well, so delay in filing the suit can be condoned.
Please, madam.
Section 5 applies to suit also.
Please.
Huh?
Please.
Yes.
Then my submission is
Section 5 of the Limitation
Section 14, madam. 14 of the Limitation Act.
Act. With that we won't say. You do it. You plead in the plaint that you are entitled to benefit of 14. 5 will not apply. We can't condone the delay in filing a suit. You have to show before that you are bona fide prosecuting this remedy.
It's liberty to file civil suit, madam.
Yes. Learned counsel for the appellant. Admitted liability, right?
Admitted liability, my lord, the rights which are approved to the parties, the interpretation of the clauses and terms of the contract. The contract is in the realm of the
No,
private.
you tell us only one thing, mister. Is it the liabilities admitted?
My lord, this is ongoing liability, yes, my lord. Liability is there, but there is ongoing contract. Execution is still pending. Execution had been completed. Project is handed over to the government. Yes, my lord, it would have been correct. My lord, the project is still under ongoing project. The government is not escaping from its liability. Let the project be completed. My lord, it's the contractual nature, my lord, is not the public law remedy. Supreme Court, my lord,
We will hear you after some days.
Meanwhile, if I may
We will hear you on 28th November.
if I may to request your lordship, my lord, let them not press for contempt, my lord.
Nothing
They are
happens.
fine contempt with
What happens?
contempt, my lord. Again, what remains the if I say myself, my lord, what remains the interpretation is the what?
All right, you want to argue right away. Fine.
My lord,
Yes,
meanwhile,
go ahead.
I will argue.
You argue on admission, please go ahead. This is on yet to be. We thought that
I will.
you would like to support your submissions. We are giving you a sufficient notice to argue. You want an order right away, we don't hesitate. Yes, go ahead, argue on admission.
There are two other connected matters are there. My lord, let them be held on 28th of the. My lord,
That's what we said. You are saying what purpose will be served?
request mail it is to let them not press for contempt.
No, not like this. It is his choice. We are not. You argue on admission first.
My lord, there are
You want
two
an interim
interpretations
order.
are there.
If you want an interim order, please argue.
And
We will
28th,
decide.
your lordship may.
Come ready, mister. We are not inclined. It's an admitted liability. Only other, probably perhaps you can, we don't know what is, you can argue about rate of interest or not. That's the only thing. In case of an admitted liability, you cannot get away by saying it's, had you disputed it, then it would have been a different thing. If in case of an admitted liability, there are decisions of Supreme Court which say that the writ court would be well within its rights against the state and instrumentalities directing this thing.
I will argue
you
at
to-
28, my lord, as you
List
have
for-
indicated. I will argue.
List. Yes.
The land court had passed an order,
Huh?
without hearing me, without any notice to me, my lords.
Huh.
Actually, in this particular case, my lords,
This is an interim order, right?
there is a status quo order already given by
No,
the.
interim order, right?
Yes, my lords.
So then, why can't you file an application seeking vacation of this order? And how is it a judgment within the meaning of clause 15 of latest patent? 15, clause 15 appeal would lie if it's a judgment. Doesn't decide, you have the remedy, file an application seeking vacation of stay.
My lords,
Whatever you are arguing in appeal, please argue before learned single judge.
my only concern, my lord, the status quo order is already granted by the competent civil court below.
Go and tell him. But what prevents you? All right, if you insist, we will dismiss it by saying this intra-court appeal has been filed.
The respondent bank issued the respondent bank issued an auction notice, my lord, publication. And the values of the property has been undervalued, my lord. And six properties has mentioned in the auction notice. Any one of the properties, to sell the property, my lord. The value of any one of the properties is enough to conduct the sale, my lord. So all the properties which are valued, the loan amount is outstanding is shown in 9 crores, my lord. The total property is valued.
When is the auction held?
Auctions
Held.
over, my lord, on 31st. On 31st.
Then what Satyavati Tandon says?
Say, my lord, the property has been
You
undervalued.
know what? Satyavati Tandon, 3 judge, you have gone through Satyavati Tandon. So file an application under section 17 of the debt recovery tribunal, right? That is your remedy, not the writ petition. In this petition, the 14 also. This, we have, there is an order, no? All right, let. Yes. Call the next case.
Witness file, my lord, challenging the order passed in section 14 without issuing notice to the petitioner. Petitioner, my lord, is the lessee as well as the borrower in dual capacity. A notice has not been issued to the petitioner before passing an order. Page number 13, your lordship may kindly turn to the order, which is at page number 13. My lord, as per the judgment of Supreme Court, my lord, a notice has to be given to the person in possession of property when he is claiming to be a tenant. My lord, I have filed the lease deed also, my lord, a copy of lease deed. It is page number 65, though it's under.
We will entertain petition only on the undertaking that you will not sell the property.
My lord, I am, my lord, I am the borrower, my lord.
You will not sell the property.
No, I will not.
Right.
Not sell the property. But moreover, that, my lord, 1,200 students are studying the school. The school is being run. And the
So you think about settling the matter, instead of they want, like we will direct issuance of notice, they will again 2 months pass an order. You will stand wherever you
My
are.
lord, we'll settle the matter.
You, better to settle these matters in the interest of students if they are studying. So only on this ground we are entertaining. If it is found that notice has been issued to you, we will dismiss the petition.
No, my lord. Even the order doesn't say, my lord. Order doesn't say the word.
We don't know. We are recording your submission.
Order.
Learned counsel for the petitioner submits that the based on 16th November 2023 in the meanwhile.
I've already mentioned, my lord, that position has been obtained from.
Taken then?
Subsequently, my lord, the position already has been obtained by me.
So obtained from. So then there is no notice is required. Then no stay. Delete that. Issue notice, proof of service list on
May it please your lordships, I beg to represent Ramarao. Because the writ petition is filed assailing a report which your lordships will find in pages 26 to 29, wherein the objection to the inclusion of a person non-resident of the area.
We have dealt with this
Your
issue.
lordships have dealt with.
We have passed an order.
Yes, may I, yes, I have a copy, I'll just pass it on to you. lordships.
You have the remedies under the act, right?
Made the representation that in that matter, your lordships, where your lordships passed an order, your lordships recorded a finding that no such representation was made. In this, your lordship may kindly come to the last paragraph of that judgment. May I draw your lordship's attention to paragraph 14 of your lordship's order? Para 13. After final publication of the rolls, and
What?
the petitioner has
Give us
not.
2 minutes, 2 minutes.
Yes.
So you are a candidate, right? From this constituency.
Yeah, I'm not a candidate.
That's,
I'm a voter from the area
so you want deletion of another voter.
who is contesting the election without being a resident of the area and
So that is a ground for election petition potential.
no, by contentions.
Yeah,
No.
you will understand that's a ground under section 83 of the RCR.
My contention would be this. When I make an application under
Okay.
section 21(2)(a,
Give us some. So electoral roll has been revised?
may I kindly draw you,
No, we are asking you whether electoral roll has been revised.
has been revised.
Madam,
Photos.
Representation of People Act. People Act, not People's. People Act. Yes. So, what is your case? Mr.
My case is this,
Ah.
that she, under section
No, she-
19 of the statute,
Huh? No, who are you?
I'm a resident and a voter of the constituency in question.
Which constituency?
Atyampet Assembly constituency, which is also Nagarpatnam parliamentary constituency. For the purposes of our present
So, but
petition,
this is for this thing, assembly constituency only to declare that she is ineligible to
in that
contest.
context,
Ah.
the present list arises, my lords, therefore the parliamentary constituency may not be relevant. Petitioner is a native of Chintapalli village, which falls under the said constituency. R5 is shown as a voter in the said constituency and has been given a
So
ticket.
when was this action like proceeding initiated publication of draft voter roll, objection.
I
what
will
the
tell you,
dates-
Lordship, that
dates.
I'm not on that schedule at all because I'm behind that schedule.
No, you have to tell us.
I'm behind the schedule.
No, but what is the schedule? What happened? At least you need to tell us. When draft electoral roll
But
published, when objections.
The petitioner's case, my lords, he does not spell out those details because he came to know about her inclusion.
Please find out. We will take it up on 14th if you want.
Yeah.
Because this can be heard anytime, even can be allowed on 29th if we find eventually it's a
I
case.
understand.
Before-
Your lordship may have it on Wednesday, my lords. I'll ensure that those
Wednesday.
details are produced. Yeah. I thought Wednesday would be.
Fine, whenever we can have it on 14th also.
I leave it to your lordship's will. I'm
Your choice.
obliged.
15th, right?
Yeah.
15th you want?
Any day, my lords. Tuesday or Wednesday, any day of
You
subject.
said 15th, so we have given 15th. Right? Mr.
This case, my lord, your lordship directed the NRO, Tahsildar.
What is the explanation?
Yes. She said, my lord, based on the Mandal Revenue Inspector's report, my lord, he has issued this certificate. After knowing, my lord, your lordship's order, my lord, she immediately, my lord, recommended the cancellation of that certificate to the collector.
This is obviously incorrect and it has been procured. You know it, Mr.
Yes.
The petitioner herself is saying that I was not residing and you have got an officer who tells that she is residing there. Obviously, for extraneous considerations, she has passed this order. What is this? There has to be, it's petitioner's case. Petitioner is saying that I have not studied in the state of Telangana and she says she has studied. What sort of like? And has he even tendered an unconditional apology? No.
Yes, ma'am.
No. What is the explanation, Mr.?
Explanation is, my lord,
Where is the report?
yes, ma'am.
Report of the whose report?
Yes, my lord. MRI, my lord, Mandal Revenue Inspector, my lord. It's page 6, my lord.
So
It says, my lord,
page
6, ma'am. Translated to, my lord, portion is at page 7.
which is your memo is USR number 9564. Petitioner. No notice. Where is you? Where have you filed? When have you filed? Memo USR. This is. So after the order was passed, thereafter she made. No, no. She is admitting, Mr. No, no, Mister. The question is not tendering an apology to this court, right? The question is that your client has issued an incorrect residential certificate, which the petitioner's own showing, like petitioner never said that I am studying in Hyderabad, despite that your officer grants a certificate that she was staying in Hyderabad. In the petition itself, in petitioner has said what there is no this thing. It only says I have hurriedly signed. So they can do anything, right? Hurriedly. The rush of work I have signed on the certificates. See, brother. It doesn't say Mandal Revenue Officer and all that. So where is that enquiry report? Enquiry report. Page. So then he should also come Mandal Revenue Officer. Huh? "18 years, Alampur village." She is not residing, Mr. Petitioner is not residing. You, how this is? Huh? No, but it is residence. If she was prosecuting her studies in an educational institution situated in Andhra Pradesh, how do you say that she was residing at Alampur village? See the way you are functioning, Mr. And we have required to issue a bailable warrant. She did not appear. She is. That means that means that you have not been able to convey the seriousness of the matter to. It's more about petition we have already held is not entitled to any relief, but we are shocked the way you are functioning. The petitioner says that I have not studied in Telangana. Your officers say, and revenue inspector and Tehsildar say that she is studying, staying in the village. How? In compliance of the order dated, which was the interim order 3110. No. Ah,
My
Yes.
view of my lord, learned senior counsel appearing, my lord, he is ended up in traffic jam, my lord. Kindly pass it over, my lord.
huh? No, it is only for fixing an early date. We will take it up in January 24.
Don't eliminate.
Unknown delay application and stay petition are also pending. As there is a delay of 1543 days. That's the lordship directed us to file an additional affidavit. We have filed and my land friend has filed counter. Let's
Kindly pass it over, my lord, senior counsel. There is abnormal delay in filing the writ appeal, my lord, there is no.
Huh?
There is abnormal delay in filing appeal. my lord.
We will hear you after some this thing, 21st November. List on 27, 28, right? List on.
Council on record requested for pass or is held up in 30th.
Oh, this is early hearing, mister. Fix a date for early hearing.
And yesterday this matter came, my lord.
Ah,
Is for to hear the vacate stay,
Ah.
unconditional stay was granted
ah.
in relation to SARFAESI action.
What is SARFAESI action 13.4?
This is, we have taken steps under the section 14.
14.
Fiscal portion of the law.
Ah,
He is held up in the 30th court, lordship. I request for.
all right. So it will, you better call him. We will pass it over, but it will immediately be called. We don't wait till 2:30, right? Ah. I'll call him. Yes, pass over. Ah. Which judgment? What is the issue? Are covered, right? Against you. State? Oh.
Correct for petitioner in item number 29 here.
Yes, this fact has been recorded. At your instance, it has been adjourned.
Lordships.
Mark the presence. Your case is which case?
30, item number 30, your lordships.
Not covered by this judgment.
Covered by this judgment, but I am the petitioner in this case, your lordships.
This division bench, why we should not follow? Once we have granted adjournment to you, so this division bench is
Lordships, a small submission, my small submission. Only one paragraph I will read. Page number 27, your lordships. Item number 30, page number
so
20.
which 30 and 31 you are arguing, right?
30, your lordships.
30.
Yes,
So
sir.
remaining, Mr. Madam, 30, 29, 31, 32. 29 and 29 you pass this order and remaining we will tell you. Yes.
Lordship, in my page, in my documents, Your Lordship, page number 27. Your Lordship, sir, regarding to this, sir, reference is drawn to this office letter of even number dated 17/8/22. On
So, Mr. Lee, is it not covered by the judgment? Instead of we will have to, all right, then we will have to
Only
find para, give item 30. You have challenged the validity of the notification dated 21/2/2023.
Yes, Your Lordship.
And this has been this thing, exactly similar, this thing, notification.
Yes, Your Lordship.
It has been dismissed.
Yes, after that, Your Lordship.
Identical. That's it, nothing. This. Yes, item 29 also, you 29, delete that order, 29. 29 means. It has been, we had given you time once, right? Yes.
My Lordship.
Yes, madam.
I'm counsel for petition.
My lords, I'm appearing for the National Medical Commission, my lords. The prayer sought for.
Your lordships, my lord, your lordships were grateful, my lord, yesterday and granted 1 day time, my lord, for filing the government orders, my lord, under which I can trace out that I was admitted legally, my lord. Your lordship may have a look at the material papers, my lord. Only one GO and one public notice issued by the National Medical Council, my lord, and then I'll leave it to your lordships, my lord. It's very clear that my admissions are lawful. I'll just take then, my lord, the respondents can argue. I'll just paste page 1, my lord. I'll just refer to the public notice issued by the National Medical Council, my lord, and one GO. Many GOs are filed, my lord. 117, 118, 119, 125, but I'll refer only to one GO, my lord. That is GO 118, my lord. First, I'll take your lordships, my lord, to the public notice dated 27 July 2023, my lord. Page 1, my lord. May I read, my lord?
Yes.
May I read, my lord? I'll just conclude in 5 minutes, ma'am. Public notice dated 27 July 2023, ma'am.
No, we are, Mr. Counsel, you should be clear in your mind. We are not placing any time limit. Feel free.
Grateful, madam.
You should be satisfied that you have been heard. She
grateful,
is telling, she was not arguing, she was only telling that I am appearing for MCI. She was not arguing the case.
I'm
You had the right to argue. We were trying to understand what is the controversy. Perhaps
yes.
your anxiety has given you an impression that we didn't want to hear you. Nothing like it. The whole day is yours. You can argue whenever to your heart's content. Yes.
I'm extremely grateful, ma'am.
Yes.
My lord, the public notice is issued, my lord, saying public notice 27 July 2023, NEET UG counseling schedule for the academic year 2023 for All India quota and state quota received from Director General of Health Services, Government of India, Nirmal Bhavan, New Delhi is attached with this public notice for necessary action by all participating institutes / colleges. Now this is important, ma'am, for ensuring faithful obedience of time schedule and also keeping in view the limited time available for condoning counseling. All participating institutes / colleges are directed to treat all Saturdays / Sundays and gazetted holidays as working days. Now, my lord, what is not faithful, my lord, is not reasonable. What is not reasonable is arbitrary, my lord. Once it is arbitrary, it violates Article 14, my lord. A.K. Roy Power Azimunnisa Begum's case, my lord. Your lordships are aware. Now I'll take your lordships to the table, my lord. Table your lordships is NEET schedule 2023. My lord, first round of counseling is so and so date. Last date of joining is so and so date. I'll straight away. Then stay vacancies. Item 7, my lord, is so and so. Then last date of joining is 30th September, my lord. Now commencement clauses is 1 September 2023. Now, my lord, 71 days.
They should fill up the vacancies with them. This is the purpose of holding the counseling.
Now, my lord, I'll take your lordships to page 9, my lord, the relevant geo under which I was admitted, my lord. Page 9, my lord, that is the geo dated 27/2017, which is again reiterated in 2022 as well, my lord. My lord, the earlier geo is minority, therefore I am ignoring that, my lord, and I have taken your lordship straight away to 118, ignoring 117. Now your lordship may have a look, my lord.
117, this
is minority, man.
Page 9.
No, man. I've taken your lordships to 118, which is page 9, man.
Ah, page 9, right?
118, my lord. This pertains to non-minority colleges.
118. Acha.
118, my lord. This, my lord, order, the geo read above orders issued notifying amendments in the Telangana state unaided non-minority professional institutions, regulations of admissions into undergraduate medical and dental professional courses rules. In the circumstances stated, so and so is issued, my lord. Now I'll take your lordships to the notification. Notification again, my lord, under section 15 it is issued. Now your lordship may see the amendment, my lord. The amendment existing rule is all unfilled seats under category A after final counseling will be surrendered to the convener, selection committee constituted by the competent authority who is vice chancellor so and so. Then, my lord, B seats and filled by the convener by merit. If any seats,
who is convener?
If university. If any seats for all the process to be completed before the closure. Now, my lord, this shall be read as, we go to the next column. All unfilled seats after the mop-up round by the competent authority under category A, B, and C may be filled by respective medical institutions following merit. From the NEET merit list, as per rules in vogue, all the processes shall be completed before the closure of admissions. No seats shall be filled up after the closure of admissions in any form. Now, my lord, this is what this says, my lord, and again I will take your lordship's to the page 1, my lord, for a second. Page 2, bottom, your lordship sees, my lord. After 71 days, suddenly, my lord, they say another counseling. After 71 days, after the classes have commenced, my lord. Now, your lordship sees the page 2, my lord, of the material papers. Page 2, bottom, your lordship sees, my lord. Note, for ensuring faithful obedience of time schedule and also keeping in view the limited time available for conducting counseling, all participating institutes / colleges are directed to treat all Saturdays, Sundays. Now, my lord, this college was permitted a ceiling of 150 students, my lord. 143 students have verified, 143 students were directly allotted by the convener. 7 seats were vacant, and on 39/2023, my lord, we stepped in. And we completed 71 days of classes, my lord. And now, your lordship may have a look at the next final government order, my lord. I will take your lordships to. That is page number, my lord, 19. Again, my lord, this is 2022 GO, my lord, which says the college can do it. My lord, at this is the GO number 127 at page 23, my lord. Clause 2.2, my lord, at page 23 of the additional material papers, my lord. Your lordships got it, my lord. This is a 2022 GO. GO is 127 dated 22/9/2022 with reference to the GO 118 which I had read to your lordships just now.
Where is Mr. Rao?
And my lord, the 1 second, my lord, the Honorable Supreme Court, my lord, no court in the country, my lord, has ever said disturb the academic schedule, my lord. Your lordships have been stressing, don't disturb. Now, my lord, the internal exams are on 26th December, my lord. 71 days classes is over.
20% case is over. 20% course.
December 16th, my lord, internal exams. And unless a student gets more than 50%, he is not allowed to write the final exam, my lord.
No, we are not concerned with appearance in the examination.
Yes.
We are concerned with cancellation of admission.
They are not faithful to the schedule. They are not faithful. They are unreasonable, illegal. It means arbitrary. It violates Article 14, my lord. Once it violates Article 14, my lord, the golden triangle, 19 and 21 step in. Protect me, my lord. I can't go anywhere now. And the college says, my lord, no, we are bound by NMC. State government vice chancellor says, my lord, we are bound by NMC. We too have affiliated colleges with the NMC. And now NMC, my lord, has not taken the academic element that is involved in the process of decision making that culminates, my lord, in reframing the schedule. They want to do the scheduling afresh, my lord. That your lordship may consider, my lord. This is my respectful submission.
That's all.
Yes, ma'am.
With your permission, my lords. My lords, these are illegal admissions that have been made by the college without online counseling, my lords. I'm requesting your...
But this, what do you, this thing, please see page 7.
My lords, I'm requesting your...
Page 9. He has referred to a rule which says that we will find out whether it is in accordance with merit or not. That's a different thing.
I'll take instructions on page 9, my lords, but the Honorable Supreme Court and also the NMC regulations...
Find out, madam.
They mandate that admissions, any kind of admissions, including stray admissions, can only be done by way of online counseling, my lords.
Correct. That's what our impression was yesterday, and that's why it was adjourned.
In fact, similar came up before the Honorable Nagpur bench today, my lords, and they were pleased to dismiss the writ petition because these admissions, even in that case, were made offline, my lords, not counseling.
Yesterday we were not convinced, madam. We were also like, we said the same thing, but he has relied on page 9, right?
My lords,
If the rule may be contrary to law laid down by Supreme Court. It has to be struck down.
Yes,
That's
my
a
lord.
different thing.
Yes, my lord.
But nonetheless, what do you say in the face of this rule?
My lord, these
Educational
were
institution,
take instructions on the
and we will
page
find
7,
out
my lord.
whether it is strictly in accordance with merit.
I'll take
We have,
instructions.
with this aspect needs to be inquired
Yes, ma'am.
whether or not it must not be in accordance with merit.
It is not.
Because-
The letter says they approached the college on that day, so we have given it across the desk. It cannot be on merit, my lords. Page 9, my lords.
Neat merit, the admission has to be as per the neat merit list.
Yes, my lord.
It is out of the.
I don't, we don't.
This is clearly not as per the merit list, my lords, and in fact, the honorable.
It is from
So you seek instructions.
I'll
You
seek instructions, my lords. Tuesday, if your lordships permit, my
Tuesday. Tuesday we will take up, Mr.
Yes, let them not disturb me, my lord.
There's nothing, nobody will, this Deepavali, they will also celebrate.
No, my lord, they are, they are going to do counseling, my lord. Let me not be disturbed, my lord.
You participate in the counseling also.
Yes,
You
let them
participate.
not disturb me, my
No,
lord.
no, we will permit you to participate in the counseling.
No, let them not disturb me, my lord.
My lords, I am objecting to
71
that
days
prayer,
of
my lord.
classes I have attended, my lord. Even now, new entries, my lord.
No, this is no argument, Mister. Once your entry has to be prima facie legal, they don't have an answer to this GO. That's why we are entertaining. The 20% or 40, this see, we may tell you, a division bench of Madhya Pradesh High Court had cancelled the admissions of students who had completed even 5-year courses in case with Vyapam. I had the privilege to author the judgment that was upheld by Supreme Court. So 20% course doesn't help you. We have cancelled the admission. I, as a judge of Madhya Pradesh High Court, has cancelled the admission. Those who had completed even 5-year course because they had obtained admission by fraudulent means. So therefore, merely by 20% doesn't happen this thing. 20%, therefore, you are immune from any action. We will not accept this submission. Merely because 20% is over, we will not. They don't have an answer to this GOMS. That's why we are granting time. Let them participate in counseling. That they can do.
Yes, ma'am. And based on merit,
Let them not dislodge me, my lord.
Will you select the irrespective of merit? Huh?
my lord, it's very surprising that the you.
Oh, correct.
Unfortunately, my lord, she is
1 minute,
from the
correct.
university, my lord.
Huh?
See, my lord, your lordships are referring to Geo and she is arguing on some other point. My lord,
No.
me to continue.
Not we are. Huh?
Your lordship may allow the petitioners to continue. They are,
No, you participate in the counseling. We will permit you to participate in the counseling today. Yes.
my lord, let them not disturb me, my lord.
No, nothing. Nobody is disturbing you. It's all subject to result of the writ petition. Nobody is disturbing you. We are sure that no examination will be held on the day of Deepavali and on a Sunday. And you can't be debarred from
My lord, if they allow someone else, my lord, the college will turn us out, my lord. That's the only worry, my lord. The students are totally under panic, my lord. Even the parents, they are under panic, my lord. Because if new students are allotted, college will directly and the university, my lord, they are
what like
agency, my lord. That's my only submission, my lord, to your lordships, my lord.
No, this is Mr. We are not convinced about what you are arguing, but still, I mean, this point has to be examined. If this authority is given, like it will turn into payment sheets, like transactions 50 lakhs, 25 lakhs, whosoever offers group admission, it's deliberately vacant and if.
As per the.
My lord, the college is saying we have to go by.
No. You have to show that the admission is as per. We can still ask you some inconvenient questions, Mr. Firstly, there is no pleading in the petition. You are only filing documents, right? Number one. Secondly, it is still not clear that admission is as per neat merit list.
It's as per merit list. Let
Where is the averment?
come out with, my lord. If
Where is the averment? In the petition, show us where is the merit list. You tell us from the merit list that this was the last candidate admitted in straight round of counseling. Therefore, I am number 1 in merit list. And I am the person who is the next.
Yes, my lord.
Tell
Let
us.
them come out with the details, my lord. Then.
What like every day we put questions to you, you listen. I will come out with details. What is this? You get this case listed on a we accommodate, then you the moment last question you say I will come out. What is this
Really
like? I mean,
grateful to your lordships, my lord.
no, we are putting questions. Perhaps we should have dismissed the petition saying that there is no material.
I totally agree.
There is no pleading that you have been inducted into the course in accordance with the rules. No
I
pleading.
totally agree, my lord. I have no.
There is no question of agreeing or not agreeing, mister. The order, you see, we cannot keep, please understand, our job is not to keep everybody happy, and we can't keep, because 50% will always be against us. If suppose we don't get relief, they will always make faces. So it's not a question of agreeing or not agreeing, it doesn't make any difference. We are not against your plans or in favor of MCI. We only want to decide this case in accordance with law to the best of the capability. It's not that. You see, you are a senior counsel, you are seeing. Yesterday you got this case listed on a mention memo, we granted. Yesterday you sought an adjournment, you filed without amendment, you filed this bench. This again we are making a query, you are again saying I will come out with the case.
I'm grateful to your lord.
This not like done. Instead of putting question, we should dismiss that there is no material to show that you have been admitted in accordance with the merit list. Right?
I'm grateful to your lordships, my lord.
Not grateful. This is contrary to Supreme Court. We cannot give effect to this.
No.
Madam, it's being adjourned only because you want an adjournment, right?
Yes, my lord.
Yes.
My lord.
You want an adjournment, otherwise we would have passed the order. He is already obliged to us for passing an order today to dismissing his
My plea
petition.
is that these admissions are not as per merit. They have been conducted offline, which is being admitted by them at
So
page
that's why-
22, my lords.
All right.
They are saying candidates who have approached us for admissions on that day. There is no mention of a merit list. There is no mention.
Obviously not, it's not in accordance with the merit list, otherwise all these facts would have been pleaded.
Yes, my lords. In fact, page 18, I am requesting your lord.
But you have to show, madam, he is not showing that it is in accordance with merit list. You have no material to show that it is not so. What do we do? That's why we are adjourning the case.
My lords, I'll-
You are seeking an adjournment.
No, my lord.
Mr. Where is Mr. Rao? You don't open your mouth, right? Huh?
So end up in other my lord, you was supposed to come.
So that's why senior counsel for petitioner is justified in saying that she is, with regard to GOMS, she is arguing and you're not even opening your mouth. It is not our case, mister. We are not university or MCI.
Lordship, may kindly see page number 18, my lord, of the affidavit, my lord.
No, like what this invitation, right?
Sorry.
When we have asked you, then you are saying. Otherwise, as if you are under no obligation to say anything. And we have told us, because we know, we asked twice, where is Mr. Rao? You are looking there. Like this means giving us that he is there outside corridor gossiping. Huh? What is this, Mr.?
Lordship, may put it on 14, my lord.
My lords, if they are filing any additional material papers, I'm requesting that they serve it ahead so that we'll be able
Not
to
additional,
take
they have filed it right without any pleading. It has been filed.
served it on as my lords, or else I would have been able to take instructions on the GO. But at any rate, NMC regulations will prevail over the state GO, my lord.
Mark the present.
Great.
Notice to respond number 5. Then what? Notice to R5. They will get, he will get him. Notice to respondent number 5. Personal notice proof. Yes.
Yes.
Yes. Ah. Oh. Who had appeared? Which council? Huh?
Council on previous occasion.
No, who had appeared just now? He said Paso. Learned councillor appeared in the. Is there an order passed?
Yesterday.
Yesterday order is passed.
Yes. Like
Where is that?
deemed as vacate.
Also, then you should be happy, right?
Yes, Milord, but
So, all right.
saying
No, not saying. Then don't say. By way of indulgence, hearing is deferred in compliance of the. Where is that order? But you don't have the file. In compliance of the interim order passed on 9. Yes. Yes, Mr.
It is coming up for restoration petition.
Restoration.
Yes. The advocate on record had become a senior advocate and original advocate on record had become a senior advocate and also advocate general for the state. Therefore, there was a missed date on 3/9/2014. It was dismissed for default. And on 25/11/2000.
No, but what is it? You instead of focusing on restoration, you should tell us what is the petition about.
Yes, the main petition.
See, then despite this, it will show, Mr. Why we are after this and incurring displeasure of all of you is, I mean, we are not like this thing concerned about, like we are not here to contest an election and to please everyone, but the object is to decide this 2000, it is on the statistics that petition of the year 1989, 2000 are pending. So by this thing, we can simply get away by restoration and forget about it, but that's not the object. This has to be erased from the record that 2000 in Telangana High Court petitions are pending for more than 2 decades. That's the idea.
Yes.
Also, please go ahead.
Yes,
my name was appearing for the respondent church. They are not aware of the product of the because this is long back in 40. Notice has to go to the party.
See.
And I am pledging. We'll issue notice. We'll
look at 14 forms.
And no, you don't appear.
14
you have no instructions, you don't appear. We will deal with it, right? If any adverse order is passed, you can challenge it under Article 136. We will deal, don't appear, right? Your name has appeared.
The name was recorded.
Acha, all right. That's why you are appearing. What is your name? Lani. original application does not survive.
Okay, sorry, but I have to clear up.
It's not that difficult, Mr. Reddy. It's not that difficult to understand that you had instructions to appear in the writ petition which has been dismissed for default. In restoration petition, you don't have any instructions to appear. It's not that difficult to understand that we should be told thrice or 4 times.
Cannot be affected by future in the.
No, nothing, no future. You have said that you have no instructions to appear in this restoration petition. Office is directed to delete his name. Why? Sit down, please sit down. Yes.
But my apology.
Why?
There is no note prepared, my lord, because we've received the paper.
No, what is this? What is this?
Quickly, my lord, take your lordship's
No, he is not appearing. So for restoration, we will have to issue notice. You take notice and serve them.
Yes.
And on the day of restoration, we will hear it. Come with the note.
Yes.
We will restore it only on the condition that you argue.
Yes,
we will give you a
ready
date.
to argue today also, my lord, but only thing today is not.
But
yes.
You see, right? Counsel has no instructions.
Yes.
He will advise him to file SLP that without notice. I was watching the proceeding. Paper is restored without notice to me. Huh? So what do we do then?
I'll issue notice.
So how can he has a right has wasted in him on account of dismissal of your writ petition. So whether that wasted right can be taken away ex parte, that is the legal question.
Yes,
correct.
Notice would have.
So therefore you will have to serve. Sole respondent.
2 respondents.
2 respondents. What is the petition about?
No relief is claimed against 2, but my lord, 2 respondents. Petition, my lord, is about against the DRT order under a DRT Act, my lord, 1993 Act, where there is no appeal against an IA passed by the DRT order. Where
why no appeal any order?
At that time, my lord, there was a judgment, my lord, at that point of time in 2000, but now it has been pending and admitted for a long time. That itself is a ground, my lord, for not delegating for alternate remedy. But a simple case, my lord, where evidence is complete, fill up the lacuna and amendment is filed, and that amendment is allowed. It is directly contrary to the cross-examination admissions that were made by the respondent. Against that, my lord, amendment is held null.
Yes. So 23rd November, you do whatever you take to, and we will come with a note on that day. 23rd, we will decide it.
Yes.
So indirectly, the respondents have also received the instructions that 23rd it will be. He will appear on 23rd, not today. So issue notice. Petitioner shall take steps to serve respondents. Personal notice, proof of service. Ah, 37.
But, sir,
37 you are appearing.
But I am appearing for the petitioner.
28.
But this matter may have to be sent up to Andhra Pradesh High Court because the petitioner
37.
37 has to go to Andhra Pradesh High Court.
Huh?
It has to be sent to Andhra Pradesh High Court, my lords.
Why?
Because as per the Reorganization Act, this matter has to go there because the subject matter of the dispute and also the respondents, they're all connected with Andhra Pradesh.
Learned senior counsel for the petition.
Lordship, this review petition is pending. Before that, civil appeals are pending before the Honorable Supreme Court, Lordship. May be taken up after that decision.
Huh?
Against this order,
which order?
Civil appeals are pending before the Supreme Court.
Then, so simultaneously you are prosecuting civil appeal, review petition, whatever.
No, review petition is filed by us. The respondent have filed the civil appeals. Government has filed civil appeal.
So,
in the writ petition, respondents have.
Mr. Please understand what will prevail. What will prevail? We are asking as like students of law, what will prevail?
Let us wait till then.
What will prevail? eventually what will prevail? The order passed by the Supreme Court will prevail under Article 141.
Yes, my lord.
Then what is the use of keeping this review pending here? What do you go and contest, sir?
After Deepavali festival.
There's no point, right? We cannot, in contravention of the order passed by the Supreme Court, we cannot grant any relief to you in review petition. So what is the formality of keeping this review pending?
Because some lacunas were there in the
No lacuna.
judgment, it was find out, my lordship.
No, nothing, no find out. This admit the heard on I.
I beg to appear for the petitioner. This writ petition challenges the constitutional validity.
Implead and this thing, whatever, implead, there are two implead petitions.
Yes, one filed by us.
Petitioners are private parties, my lord. They want to oppose my writ petition. That implead petitions may be allowed, my lord. I have no objection. Because the attack is about the constitutional validity of a state act. 2006 writ petition, my lord. I have a small note.
14 November, Mr. 14 November. Right?
A week later, my lord.
Yes, my lord.
14 November. Not like today. This issue where your assurance requires the matter requires consideration. I will have to pass a long order running into some because if we have to
The last case, my lord, Supreme Court judgment constitution. Manifestly arbitrary. Government executes a sale deed in favor of the petitioner, registered sale deed executed by the governor of the state, and issues an act, ordinance and act, annulling the sale deed. So the legal validity and the constitutionality of the act, which is annulling my registered sale deed, is subject matter of challenge.
14 November.
20th.
Why?
20th. AG requested.
Yes, Mr. What do you say? 20th. Please argue. He is ready. He is with the notes also.
I have circulated the note to the.
All right. Yes. Learned so and so.
And 1 week time, the gold matter will not during the execution of the work, the petition was filed. And now the work might have been completed and the accounts might have.
What is the prayer?
Effect recovery of the chainage charges may not. Chainage charges being recovered by the department.
Was there any interim order? Interim order staying the recovery.
Thereafter,
That's why he doesn't know. Interesting. Interim direction as prayed for. What is like, what is the subject matter?
Subject matter regarding the law, in a irrigation project, my lord, where the needs, my lord, they are affecting clearer charge for the earth, my lord. The contention of the petition is that on the
So obviously list survives because there is a stay order operating. So please argue.
my lord, another three matters also there.
Now we will call it. You please argue that this will also.
My lord, I have to settle from client whether survives, whether.
No, survives because there is a stay.
But the work is of 2008, my lord.
So
work might have completed by this time and accounts might have only to the extent only.
recovery of.
Right.
No, so work is complete. Whatever accounts have been closed, whatever we don't know. That's what he's saying. No, he wants to find out. Do you know what happened? So next date 14th you argue, Mr. List. No. Huh?
What 15th you learn? 15. Yes, 14, 15. That's it.
So Learned Council for parties jointly.
May I please, no further orders need be passed.
Hmm?
No further orders need be passed, my lord. Earlier, my lord, the writ petition came to be filed in 2010, seeking direction, my lord, to stop illegal mine. No interim order is there, my lord, due to passage of time.
Learned Senior Counsel for the petitioner. Huh?
It's also become infectious, my lord, the old matter.
Same order.
May I please? This case, my lord, I filed questioning the illegal layouts, my lord, in Aiz and Pullur villages in Mahbubnagar district, erstwhile Mahbubnagar district, my lord. Some of the real estate owners, my lord, without following the layout rules and everything, my lord, they privately made layouts and selling the poor people, my lord, apart from they are not giving the share, that share of the 10% to the concerned Gram Panchayat, my lord, I filed this petition, my lord.
Is it public interest litigation?
Like public interest litigation, my lord, but one of the reporter, my lord, from Aiz village, my lord, filed this petition, my lord. So he sought for information they have not given, my lord. That's why I filed petition, my lord.
Which are the illegal layouts?
I sought for information, my lord, but they have not given, my lord. I made an application.
Nothing, Mr. This is absolutely vague.
33, my lord, I made a.
What are the illegal layouts? No, no. That means if they don't supply you information, you will file PIL. Huh? What is this, Mr.? You are this thing. Public interest litigation is not like a place where you can throw the garbage, right? A high court is not a place. They don't supply information, come and throw the garbage in the court. After 13 years, they say not supplying. It's your duty. You tell us why it should not be dismissed by imposing exemplary cost for filing this frivolous thing without specifying what is the illegal layout. Unfair, Mr. Yes, this petition has been filed.
Steps are being taken against the illegal layouts and notices have been issued to those developers who did not pay the conversion charges, Your Lordship, and also given an advertisement
So,
to pay the charges with regard to the, actually,
will be taken as preferably within issue of notice.
as the counter is filed.
What have you done after the issue of notice?
This counter is up about 2011, Your Lordship. I'll get instructions.
So
Recent
you
instructions
are intervening to seek an adjournment, right?
No, Your Lordship. Counter is with regard to the notices were issued earlier, Your Lordship.
Following reliefs. Paragraph when the matter is seek an adjournment.
I'll leave it.
Then we will have to then, if you want to take it, then what did you do for these long years after filing counter? File an explanation then and ask them to appear in person.
As the matter is listed today, Your Lordship, I need to get instructions. That's why I'm requesting Your Lordship.
Who has asked you to seek instructions? What is asking? Petitioner has asked you in the corridor that seek instructions.
No,
That
I'll leave it to Your Lordship.
so if you can't, again we will with folded hands we request you. If you can't assist us, we don't expect any assistance from you. If you can't assist, don't obstruct the course of justice. In 12 petition pending for 12 long years, don't. The court is trying to decide old cases. You stand up just to seek an adjournment. Mr. Prasad, please tell them. They are young people associated with you. Please tell them. The petitioner is conceding that in the whole petition, there is no averment about the illegal layouts in respect of which petitioner is seeking a relief. We are dismissing the petition. We are not asking her. She is praying for time to seek instructions.
I'm sorry, Your Lordship.
Why?
My attention to.
At least advise them. And should we say that contrary to the stand taken in the counter, she is praying for adjournment? What will happen to her? And send it to the government law secretary.
I'm sorry.
That this is her performance. That contrary to the stand taken in the counter, she is seeking adjournment. Please advise. Please advise. They are like sufficiently experienced people. And they must be good. That's why you pick them up as government advocates, right? Huh? Ready to, I mean, petitioner is conceding that there's nothing in his case, right? And she's like, just see, we have dictated the order. She's interrupted us while the court is dictating the order. She doesn't even understand that if the court is not hearing us, her, that means no adverse orders can be passed against her. This basic thing also, we are dictating the order. She is interrupting and seeking an adjournment. Please, madam, sit down. We will deal with it. It's our case. We will deal with it. It's a public interest litigation. We will deal. Don't do this thing. Yes. So do some homework, Mr. and then file proper PIL, right? Not like this, just saying anything. Yes. Yes, madam.
Please, Lordship, the present writ petition filed for seeking direction to the respondents Millard implement the guidelines specified in 1825 of 2000.
Guideline what?
Millard
What guideline?
and Geo 20.
Inaction on the part, not taking steps to what is guideline?
Millard, who is the government employee? They have to stay in the headquarters of the workplace, Millard.
Any steps to implement the guideline? 8/2/2001. What is the guideline?
The employees has
Which
to
page? Have you filed guideline?
Yes, Millard. Yes, in this Millard, the Honorable Court direct the respondent to file counter, Millard. Till now, they are not filed any counter in this
Let
regard.
them not file. They don't want to file. Yes. You argue your case. Nobody is asking for time also, you have seen, right? We can't help it. You argue. What is?
I am ready, Millard.
Yes. So what is?
15th, Millard.
Yeah. No,
I'll
what
give
is?
you that copy.
It's simple, right? What
Yes,
is the
yes.
guideline dated 8/2/2001?
Millard, that is modified, Millard, 8 GOMS number and guidelines, specified guidelines 1825 of 1959. That is amended as a GO 20 of 8/2001.
The prayer is this thing 8/2/21. Where is 8/2/21?
That stated, Millard, government employees has to.
GO, madam, where is that GO? GO which you are challenging, where is it filed in the material papers?
Millard?
The GO which you are challenging, is it filed in the material papers?
That's why I want to verify, Millard, it is in.
It's your case, madam.
Yes, yes, that's
When you're
true, Millard.
challenging a GO, the minimum expected is that you have to file the relevant
Yes,
GO.
that's true, Millard. That's
Then you
why I
said you
want
have
to, once again, if it is not in the file, I hand to hand over this
Don't
thing.
verify. Don't talk like you argue. You are ready. You just now told us, please argue. Yes, Mr. Is it on record?
GO 20 is on record, what? Page 30. GO
Page
20.
13.
GO 20
That is what
is there on
she
record.
wants the implementation. According to Rule 45, traveling along rules.
Kindly go to para 4 of the GO. Government having reviewed the issue hereby instruct all concerned controlling officer immediate steps to ensure that all officer employed under the control individually reside at headquarters and available at the
But an urgent call of duty, all heads department request to follow the instructions.
So it has lost infructuous. This period has expired.
Yes.
Yes. Yes, madam.
Lord, shall I get instructions?
No, nothing. Please read. Read GO 8/2001.
Yes, my lord.
It has become infructuous, madam. That was 2001. They were directed to report for duty and all that. It's all over. Nothing can be done after 21 years. See. Please see page 13.
Yes, that's.
You agree, right?
I agree, but my client is not agree.
Then ask him to go to Delhi. If he doesn't agree, that's the only judicial remedy available to you. We can't also.
If I agree, my lord, they blamed me.
No. We will not record your concession, madam. We are passing our own order. We are not dependent. We understand that they will ask you how would you agree. But we are sure that nobody will contact you after 13 years. They must have forgotten that they had filed any such petition. Right? Yes. In this writ petition, comma, the yes.
Obliged.
With your lordship's permission, lordship. Item 47 has become infructuous, lordship.
Learned counsel for the petitioner submits that the writ
Obliged.
Item 48, he has not.
For the respondent to that, earlier I am the standing counsel. Already I files for handed over to the department.
no entry model. No entry. Nothing surveillance. What? Nothing surveillance. Yes. In this writ petition, the petitioner name. Then it comes. Yes, in this writ petition, comma. That they will write. You will write no, none appears. That you will write no, that or I should tell that none appears.
My lords, I may be permitted to represent Mr. UD JBM Rao, my lord.
Ah, yes.
My lords, Mr. UD JBM Rao requested me to represent before your lordships, my lord, because
No, no,
his
it's all
family is
right. No, what is writ of mandamus not excluding Telangana area, Dr. Justice Naik. Tell. What, Mr. Now? What is the report? What is anything survives?
I'm extremely sorry, my lords, because of an unforeseen situation in his family, my lord, he requested me to represent before your lordship, my lord.
Please argue. Please argue.
No, my lords. My lords, he only requested me couple of hours ago, my lord, to represent and seek some time, my lord, because
So say so. You are repeatedly saying yes, permitted me to represent. That means you are ready to argue. You are not saying that I seek an adjournment. It is what is what? Oh,
because
this also requires right to the authorization to represent.
I may
You have only been so see how cautious you are. That the court should not put you any questions. So therefore, I have only been authorized to seek an adjournment, nothing more. Don't ask me anything, right? Huh?
No, that's not my intention.
This is what it means.
There is some unforeseen situation in his family.
Fine.
That is the reason
What is your name? Next week, unforeseen situation. What's your name?
My name is Srikant Chintala.
Learned Counsel.
Year of 2010, which is an erstwhile government lot. So therefore, which is pertaining to the Rayalaseema and Andhra.
Yes, Mister. It pertains to Rayalaseema and Andhra. Nothing survives. Right, Mister. You understand this? We would have adjourned it.
As far as I have read the prayer online, I only read prayer online. And it matter pertains to exclusion of Telangana region from the geo.
That is the exclusion from my area falling in the state of Andhra Pradesh. That is what learned government, what GP is saying. You have heard him saying, right? You can apply for restoration in case you find. This writ petition. No, we will record your submission that you have been only authorized to seek adjournment. Thereafter, we are passing an order. Nothing, sir. We would have adjourned it, provided it, and pass an order. He told belated response. Why you should not say in the beginning that it has become infructuous? After we have passed an order, you are saying. Next week.
For a-
You should be happy, Mr. Celebrate your victory. You have succeeded in seeking an adjournment, right? Celebrate it today. Succeeded in seeking adjournment. Feel happy. Yes.
Milord, for a moment, I may be permitted.
No, we have, you wanted adjournment, we have granted it, mister. Huh? Hey, first of all, unmute yourself. You muted yourself and are trying to speak. How can we hear?
Item number 51, I am appearing for the respondents 1 to 5, Lordship.
Next week, mister. Don't write anything this week. You should say in the beginning, mister. What, like same thing? After an order is passed, then you say. We could have put the question to him. No, he has now disappeared. He wanted adjournment, he has got it. He will not now log in. Yes. Yes, madam.
Item number 51, I am appearing for the respondents 1 to 5.
Yes.
My information reveals this matter become infructuous, Your Lordships.
Why?
The query has been granted the lease for 2 years, Your Lordships, 2010 to 2012. Subsequently, it was no information for an renewal, Your Lordships. We found that on inquiry, it was
Learned counsel.
actually extracted the
So this thing lease period of lease has expired.
Yes, Your Lordship.
In this writ petition, none for the petitioner. Write her name. $53. 52.
Your Lordship, appearing for petitioner. Your Lordship, the current petition was filed with regard to supply of clean water and uncontaminated water to the Chenchu tribe. However, the matter is rendered infructuous, Your Lordship. If Your Lordship may kindly close the case.
Open this. Don't tie it like this.
This.
Is it not better? You don't feel free. You feel free here. Nothing should be around the neck. This is enough. This band.
Absolutely, Your Lordship.
Learned counsel for the petitioner submit.
Please, Your Lordship. And for the appellant, my lord, the appeal was filed against the gazette notification. My lord, initial gazette notification was made in the year 1989, including certain survey numbers as properties of the work. Then, my lord, in 2008, an addendum gazette notification was made, wherein, my lord, the lands of the petitioner was also included, my lord, as work properties. My lord, this happened without notice of the petitioner, the 2008 notification. A division bench of this honorable court in a different case has taken view that whenever an addendum is issued and some more lands are added to the originally issued gazette notification, my lord, a notice should be issued to the parties who are physically, my lord, having the land, and then only, my lord, such a gazette addendum notification can be issued. In this case, that has not taken place. So, my lord, the gazette notification and also the consequential proceedings of the RDO, whereby he has issued occupancy right certificates in favor of the third respondent, my lord, has been questioned. Learned single judge dismissed the writ petition only on the sole ground that whenever you are questioning the
gazette notification of the work properties, you should go before the work tribunal only. Writ petition is not maintainable. Two things, my lord, learned Single just paid to say, my humble submission. First thing is, my lord, this happened without notice of petitioner, violation of national custom. Yes. Second thing is, my lord, I also questioned the proceedings of the RDO, whereby occupancy rights certificates have been issued to the third respondent, my lord, which I cannot question before the work tribunal. So for those two reasons, my lord, the writ petition is maintainable. Accordingly, this writ appeal has been filed against the order of learned single judge.
So what now? So if we hold that writ petition is maintainable, then remand.
Your lordship, remand it. My lord,
Because there is no adjudication on merits.
No adjudication on merits. No adjudication.
Yes, this intra-court appeal.
please, for admission.
Yes, yes. We have requested.
Yes.
You say before request. Actually, whatever you don't share is possible. All right. Call madam. 54. So this has to be adjourned. Acha, 54, 55, 56. Let these petitions be listed before a bench in which one of us.
My lords, may I submit, my lords, item 54 and 55 pertain to state of AP, my lords, the transfer to High Court, my lords.
That right. Learn it. Give it.
In fact, these went on. to Supreme
Mr.
Court and
Praveen
they've been
Kumar,
pending.
you are appearing.
I'll discuss that.
See.
I am for the respondent. In 54, I am for respondent for respondent.
No, 54 has gone to Andhra Pradesh.
Obliged.
Yes.
In fact,
We are on to
may I submit, my
56.
lords?
56.
54 and 55 also have been covered by the division bench of this honorable court, my lords.
No, but we can't decide,
Yes.
right? What is this judgment, Mr. Praveen Kumar? Appeal. The petition is disposed of with the liberty para 71. Right?
Yes.
Learned counsel for the party jointly submit
Please. Due to subsequent development, I just want to get instruction from the client matter whether to want to pursue the writ petition or not. Because challenging in the matter 3 clauses of the GO 334, the present writ petition is filed. Out of which matter second clause has already been amended by the government itself, subsequent to filing of the writ petition.
Then, obviously.
So, because there are 3 clauses which have been subject matter of the present writ petition, matter. Insofar as clause
Direction of power must have, there is a stake.
There is no stakes.
Then tower must have been erected.
Tower must have been erected, but with regard to
it's a question of dismantling.
Not dismantling, they have issued a GO prescribing 3 conditions. One is seeking NOC from the neighbors for erection of a tower. And second one is seeking NOC from the Airport Authority of India. And third condition is the subject matter is to deemed approval is not being mentioned in the GO. Because Panchayat Raj Act say if within 15 days no permission is granted, then it is to be deemed to have been granted. But this particular GO say if within 30 days if no permission is granted, I have to file an appeal. On these 3 grounds, this GO has been challenged.
What you are the person seeking erection of this thing tower?
Yes.
Then what survives?
You
must have erected the tower, Mr.
Yes, sir.
Way back in 2013. Then,
because subsequent development, one of the
nothing, no subsequent, nothing, sir. Well, you understand, please.
Yes.
What you this thing you have already erected a tower.
Yes, sir.
In this writ petition, they
One thing I want to bring before your lordship, may kindly see the cost title respondent number 1, my lord. Normally, old matters are coming, my lord, which are filed before the formation of Telangana state, my lord. Where, my lord,
so he will correct the cost title, right? You don't appear. You correct the cost title.
I'll correct.
Government of Telangana.
In fact, my lord, subsequent this particular GO was
there is nothing. We are not passing any order. The issue has been rendered academic, right? In this writ petition, the
the thing is that, my lord, this case law I want to bring before your lordship, my lord, which was held by the predecessor of this court, of this honorable court, my lord, law has been laid down. Because, my lord, on this issue, my
what law has been laid down?
here, my lord,
No, he is correcting the cost title. So what objection you have if the petition is being dismissed as infructuous? I mean, it's beyond our comprehension how any law applies and our this thing. We have understood the government of Andhra Pradesh you are not representing. We are asking him to correct. He is doing it, and we are dismissing the petition as infructuous. What objection? And one thing, why should you forget to smile? See, this is you make it so difficult for yourself, Mister. We have been telling you repeatedly, everyone, that our endeavor is to find a solution to a legal problem. Nobody is torturing you physically or abusing you, nothing. If you don't smile, we are not responsible, right? You are saying that we have forgotten to, so why should you not smile? Nothing is at least when the petition is being dismissed as infructuous and your objection has been upheld.
Yes, yes.
So you have all the reason to smile. No. Your objection is that this petition cannot be dismissed until and unless state of Telangana is implemented, right?
I thought that it's free to bring before your lordship, my lord, about the authority.
What?
This authority, my lord, it's my duty to bring before your lordship, my lord. For that.
What authority? All right, then we will hear it.
For a moment.
Yes.
I'm not interfering in your lordship's order.
No, you can't interfere, but we will decide it. What is it? What? Yes. Huh? What?
My lord, after formation of state of Telangana, my lord, most of the writ petitions, my lord, old matters are coming before your lordship. About it is incumbent for the councils, my lord, to change the cost title. Otherwise, my lord, the legal ratio laid out by this honorable court, my lord, the freedom.
No legal ratio, nothing. Most of the petitions are being dismissed as infructuous.
Yes.
No ratio.
And because in the earlier one of the writ
Now, what is, you have given us, what is it? You have to point out. We will record your submission. Meet it. Yes. What is it?
Here, my lord, after formation of state of Telangana, my lord, it is incumbent on the council to change the cost title within a year. Otherwise, my lord, the writ has to be dismissed, my lord.
Huh?
Otherwise, the writs are not maintainable, my lord. That was the law laid down by the division bench of this honorable court.
Which paragraph?
Para 5. We are not in full agreement with you.
I don't know. Then they will be. Well, they have to argue. They don't argue. Infructuous matters they want to argue. What to do? Yes. What is the what is
Here, my
what is the case on?
Here, my lord, in this case, my lord, the state of AP is being made state is not being made a party, my lord, by the council, my lord. In this case, my lord, the government of AP is being made a party, my lord, as a first respondent in this cause. Not only in this case, my lord.
No, government of AP 2013 government of AP was there in force. It was in existence. Government of Andhra Pradesh in 2013 was in existence. So they could not have anticipation of reorganization act could have impeded Telangana. Right? What?
That much only I know.
Hey, what? So what you have passed on? What is this, mister? No, burden is on us to find out.
Yes.
Huh? Hey, what like?
My lord,
Shall we write that after passing on you did not say anything about this? What is this case? What has been held? How it applies to his case? What should be done? What is your objection? Please tell us.
this case, my lord, in all the cases, my lord, which has been brought, old matters, my lord. Most of the cases, my lord,
You give this idea to this thing, council for petitioners to file review petitions, right? Huh? And to increase the burden of the court.
just to bring before your lordship knowledge, my lord.
What is it? What is the judgment say? What?
Your lordship, I kindly see, my lord, first page. When the provision of the constitution mandates, mandates in a particular way a proceeding is to be initiated, no one can change it and it has to be done in that manner alone. If it is allowed to be done in a different manner, that would amount to rewriting the constitution, no court of law can effort.
Hey, what? Hey, what is the submission? What is the objection in his petition? You tell us. He has implemented government of Andhra Pradesh. So you, by relying on this judgment, what do you want to prove? What is the submission?
My respectful submission.
Government of Andhra Pradesh cannot be implemented.
Yes, my lord, after formation of state of Telangana, my lord. This writ petition
So
doesn't.
without, we have asked him to correct the cost act. Instead of spending energy and time on a matter which is infructuous, you better focus on a case which has to be argued. That is our problem, right? The cases which require your argument, you don't argue. And in a petition which has become infructuous and we are upholding your objection, there you are this. What does this mean? Have you read it?
Yes,
What is it? Please tell us.
Yes.
Writ petition filed against government of. What is it, mister?
Yes, my lord.
We will not take cognizance of this. If this can't be done like this, you cannot. You have to tell us what is this ratio of this case, for what proposition you are relying. What is your submission? No writ can be filed against government of Andhra Pradesh. What would you want to say?
Dear my lord, of the formation, my lord, the state of Telangana, your lordship have rightly pointed out, my lord, that the state of Telangana, it has to be pleaded, my lord.
He will do it. What is your objection?
Yes, I have produced the citation in support of the lordship's observation. That much.
What to do, Mr. Praveen Kumar? Tell us. His objection has been upheld, right? Still,
Yes, my lord.
huh?
Nothing more to add.
Nothing more to add. Fine. At least we are happy that. No. His objection has been upheld. Still, I mean, we don't know what is like. You better. We will be happy to hear you with a smile in a case where something survives. Right? Don't waste your energy on an infructuous matter. Right? Fine. Correct, Mr. Costatic. Just now, write down for his satisfaction. Government of Telangana. Still, you for his satisfaction that we should be record that you have opposed the.
Most of the cases, my lord, are there.
No, you tell them that they should, all councils should file review. Tell them. Huh? So, yes. You are really going to tell them to file review. This is all infructuous matters, mister. Nothing. How are you concerned in cases you are not appearing? We are not issuing any direction against government of Andhra Pradesh. Where is the question? Are you a counsel for Andhra Pradesh government? That in how are you concerned in cases where you don't have instructions to appear? It is for that either your counterpart or the counsel for petitioner to file review. You have appeared in your case, this case, and you have succeeded. What else do you want? No, you are saying I am seeing in most of the cases. We want to understand what is your grievance in this, and can you first of all, can you make a grievance in respect of which you are not counsel? And here now, you if you can file, you file review in those cases if you can, right? We will deal with that application whenever you file. Huh? Correct the cost. Okay. Yes, Mr. Sharma.
Made under Weights and Measurements Act, Legal Metrology Act is under challenge. The petitioner appears to be a retired employee of the department earlier.
Oh, 73 years.
Yes.
Now must be 83 years.
Yes, but your notice will find para 4 of the writ affidavit. He earlier worked and retired long back. He also participated. He may be a good officer during that period in the department. I have seen the prayer also, Mirat. Your notice may kindly see the prayer is he questions the entire rules made under the act and the approved guidelines. No specific rule is under challenge. Your notice knows Mirat under unless they make out the case within the legal framework to challenge a particular rule. It is violative of fundamental rights. Restrictions are not reasonable. Nothing is there, Mirat. It's only omnibus.
Nobody is appearing also. Yes. None for the petitioner, right? Learned is.
Representing
Yes, madam.
petitioner, the matter has become contentious.
Oh, learned counsel for the petitioner. $60. 60.
Yesterday it was.
How? It was adjourned to?
Second April, December, I remember 68. 61, 62 is next week.
Next week. So how, like, who prepares the call list? No, who prepares? So we will issue notice to him. Yes. You call 63. I will deal with the registrar judicial. This is, these cases have been adjourned already.
Yes. Yesterday it was. To December 2nd week.
Yes, we will deal with this issue at 1:30. Yes.
Make clear.
No, how that nobody is. Yes.
Make clear also.
63.
Yes.
So can it be completed in 15 minutes?
Not possible.
So we'll continue. It will continue on 14th November.
May I
List
ask
next week.
the synopsis?
No, you give it when it is called. Next week. List next week. Yes, Mr. Can it be heard? Like same question to you all. So next week then, list next week. Done, madam. Next 68. $68.
This also blood, that's blood. It has to be hard blood.
Yes, heard. Next week. 68 to 70.
74.
68 to 74, Mr. List next week. Let some file be.
My lord, with your lordship's kind permission, my lord, no, my lord, item number 28, my
No,
lord.
that's over.
My lord, I was on my way, my lord.
What can be done, Mr. Yesterday also, this is not fair when the other side is not there.
No,
This is no hide and seek. Yesterday we had passed an order that writ petition will be dismissed, interim order will be vacated. You said, somebody said, or you said pass over and you didn't come. What option we have? Nothing. It's vacated, Mr. Sorry. We can't help it. We have to respect the orders which we pass. If we don't ourselves comply the orders, what can we, as it is, we can't expect them to comply. They are listing cases which have been adjourned. What can be done?
My lord, I was held up in another court, my lord.
No, nothing. Another court that shows it was more important. Stay has been vacated.
It was a bad matter.
Don't argue, Mr. Order has been passed, and we have never altered the order if once it has been passed, right? So the stay has been vacated. It will come up after 2 weeks. Do whatever you feel like. 75. Yes. What is it? Let's see if it has become imperfect. Let's see otherwise. Writ appeal. Writ appeal. All right, next week. Remaining cases next week. Don't write anything. It will remain as it is.
Where is it? May I have my lord's permission to make a mention about the CS matters, my lord? Certain cases are not listed today. They may be directed to be listed next Friday.
Yes. Which cases?
No, in CS 14, certain applications,
All right.
they were directed.
You
to be
have the
listed.
particulars, right?
Yes, I am giving the details, my lord.
Next Friday.
Obliged.
All right. Yes.
CS7, in CS7.
7.
CS7.
Yes.
Same request in CS 14.
Yes.
Subject to losses capital. CC 1384 of 2023, this matter has to be listed today, my lord. At 1310, there is no specified date for posting register as it. Kindly next week, my lord, 1710, my lord.
Which case?
CC 1384 of 2023
is listed
was
today.
not listed today, my lord.
Not listed.
Not listed, my lord.
You want
No specified date. Do respect this honorable court.
1 minute. You want its listing next Friday?
Next Friday, my lord.
Give the slip. Yes. Yeah. Lunch motion. All.
Page number 32, man.
Mr. Rao.
All matters.
Acha. Oh, all.
Lord, in that case, my lord, the representation was not there. This honorable was pleased to give a liberty to make representation.
So
Now he has
this
filed representation.
here representation has been filed, right?
Now he has filed representation.
All right. All the 4 cases, right, disposed of, certified copy today. Yes. 208.
My lord, in these matters, I appear for the petitioner, my lord, Mr. Mir Ahmad Ali. My lord, I have prepared a synopsis, my lord. Your Lordship may kindly recall this is a case where there is a controversy about 2 orders of the Honorable Court for which report from the Honorable Judicial Registrar was called for. These are those cases, my lord. I have filed a synopsis of the case.
208 to 210.
The lead matter.
11.
The lead matter is only one, my lord, WP number 7859.
And what are these remaining 3 are what? Contempt petitions.
My lords, in fact, in the light of the report furnished by the registry to this honorable court, the immediate step need to be taken, my lords, in the matter, or the registry should be directed to, my lords, lodge a complaint on that, my lords, there can't be any dispute at all. And my lords, apart from that, since the 2 orders which are fake orders relied upon are placed before this court and an order has been passed by virtue of.
So we will say that they will not be.
There is a criminal contempt on the court. Such a recalcitrant litigant, my lords, has to be tackled in accordance with law. There is no dispute at all, my lords. So therefore, my sincere request to your lordship is, your lordship may kindly direct the registry to lodge a complaint, my lord, even the Supreme Court also lodged in the recent past where 2 orders were placed before the Supreme Court, the registry was directed.
Complaint for what?
Complaint as to the fabrication of record, forgery, and playing fraud on the court, placing reliance on the court. Filing such a court orders, which are non-existent, placing reliance on such non-existing order is nothing but, my lords, the criminal contempt.
Yes.
The 3 decisions, my lords, I would my lords, these first measures have to be considered by your lordships, my lords. As regards the merit of the matter, my friend can go ahead with the matter. We will argue.
Yes.
These matters have to be immediately considered by your lordships, my lords. The Supreme Court, my lord, orders student, court officer garu. Very good. That's the question. And if you could check judgments also. Okay. This good. This is 22nd of August 2023 order, my lord, passed by the Supreme Court.
Yes.
though the notice is served to the advocates Preeti Mishra and Aftab Ali Khan as well as the complaint local so and so, except advocate Mr. So and so, none is present. We have perused the annexures A and B, page 8 to 10. There are two orders dated 25th July 2022 passed by the same bench, the same SLP bearing civil number so and so. The first order is of dismissal and the second order is of allowing the SLP. We direct the registrar to hold an inquiry into this aspect and submit a report to this court by 20th September 2023. If the registrar finds that this is the case of fabrication of orders of the court, it follows that the criminal law will have to be set into motion. My lords, pursue thereafter, my lord, the Supreme Court passed an order directing for registration of an FIR. This order is 26th September. It is obvious from the report that the document purporting to be a copy of the order of this court, which is marked by Annexure 3 in the report, is a fabricated document. Therefore, the registrar judicial listing must set the criminal law in motion by lodging a complaint with the jurisdictional police station. Though notice was issued to Miss So-and-so examining her role, she has chosen not to appear before this court today. It is for the investigating agency to examine the role allegedly played by her. The registrar judicial listing, while lodging a complaint, shall also submit a copy of this order along with the annexures referred to in his report. The officer in charge of the concerned police station shall submit a report about the investigation carried out to this court within a period of 2 months from today. For considering the said report, let the miscellaneous application be listed on 1st November 2023. My lord, sir, this identical order may have to be considered by your lordships because apparently.
Which is the order in this case?
But not the page. In the report, my lord, two orders are referred by the registrar in the report. My lords, in this, that
Am I permitted to state
my lord,
facts? Yes, if I am be prosecuted, I can be prosecuted at the end as well.
No, there should be a complaint for that. Court should have to lodge the complaint.
We will hear you. Of course, you will be heard.
Yes, my lord.
He is just trying to say what the respondents at this, what is their stand at this point of time in view of the, you have been given the report of the registrar, right?
Yes, my lord. For that,
I have been given, I have prepared a.
You have responded, no?
No, my lord, I am the writ petitioner.
You have responded to that report because time was being sought on the previous two occasions.
The affidavit has been filed.
Right.
Yes.
Yes,
my lord. The order.
We will hear you. We will hear you just now.
The order dated 28th December 98.
Page
18.
80.
Of writ petition 7859 of 2023, my lord. Where is the report of the register?
Page 80. Order dated?
My lords, 28th December 1998 purported to have been passed.
28 December 1998.
WP number 35966 of 97. 966 of 97.
996 35996.
Yes,
35966.
966, yes.
966 of which year?
1997.
97. And other order is?
Other order is, my lord, 35970 of 1997. 35970 of 1997.
Dated?
That is not there, sir.
My lord, that order is dated 28/12/1998. My lord, as referred to by the registrar in his report furnished to this court.
So these two orders are non-existent and they have been produced along with the writ petition.
Yes, my lords. Respective writ petitions.
All right.
Apparently, my lords, they are both.
Respective means which order has been filed in which petition? Please tell us that also.
My lords, in this writ petition, WP 7859, 35966 of 97 is filed.
5499 and 56.
Where is it?
Sorry.
And the other order?
the other one order, my lords. This is relied on in WP 5499 of 2023.
It's not there here today before us.
Yes, my lord. And WP 5550 of 2023.
Those petitions are not before us.
Not
right?
listed, but my lord, I am submitting about in what cases, my lord.
WP number?
5499 of 2023.
5499 of 23
and WP 5550 of 2023.
5550 of
2023. My lords, despite this fraud, what the attempt of the petitioner is further fraud. My lord, at page 43, some explanation is offered. I'll also submit on that, my lords. My lords, this application at page 41, your lordship may kindly have it. Examination of this order. My lord, this also has to be proved whether certified copies of these orders are, my lords, being furnished by the court. My lords, what order this is?
No, that's what like another, this certified copy of order dated 8/12/98 was supplied.
No, my lord, not certified copy of the order dated 4/9/1992. That is at page 41.
41.
This is not covered in the report, my lords, but they are trying to harp on how this per se, this order can be said to be, my lords, void. I will just submit a few submissions. My lords, application 342 of 1992. My lords, along with this, in fact, applications filed for passing this award also is required to be proved by the police.
What this?
This order, my lords, now
342.
Application 342 of 92. This is filed in CS7 of 5082. CS7 of 58.
CS
7 of 58.
What this order is also forged.
It is, my lords, High Court is giving certified copies of this order. Now they want to place reliance on this order, my lords.
4th September.
They cannot place any reliance on this. My lord, CS7 of 1958 is concerning a partition suit, a civil suit. The order shows what is challenged is the land acquisition proceedings. The award is challenged on the ground that no notice was issued to the gentleman. Nawab Muhammad Wajihuddin Khan. My lords, page 44. 43, the order is referred, my lord, from page 43 to 44. The contentions have been referred.
No. So what is your submission?
My submission is, my lords, even they cannot place reliance on this. Police have to probe this proceeding also whether.
Why? This is forged order.
It is not forged order, my lords, because CS7 of 1958 is a civil suit. My lord, there if the persons aggrieved of the land acquisition proceedings, what is the recourse, my lords? A writ petition, not an IA, to be filed in a civil suit.
We don't know. You are challenging this order.
I am not challenging. They relied upon. They cannot rely upon even this order certified copy of which is furnished by the court for the reason that, my lords, in a civil suit, the proceedings of land acquisition is per se void. Page 44, my lords, the concluding.
No, you are not arguing the case on merits. Right?
Lords,
Presently, you said that this that FIR should be registered. Whatever you are arguing on this, right?
FIR need to be registered on the two orders. My lords, with regard to the genuineness of this application, 342, all applications may have to be probed. There can't be any application in a civil suit challenging the land acquisition proceedings, my lords.
No, but people file misconceived applications. What can be done? They challenge order passed by the division bench before us only. So what can be done?
My lords, this can be ignored. No reliance can be placed on this order. Make a rent in.
No, so but
My lords, what?
we have understood your submission that these two orders are forced. There is you are placing reliance on the report of Registrar Judicial and you are relying on Supreme Court to say that criminal law should be set in motion. This we have understood.
This is the identical order. My lord, the same identical order relating to the land acquisition. Certified copy is furnished by this court. Whether it has any probative value to consider in a collateral proceeding. My lord, this need not be considered for the reason that in a civil
we will decide whether when we hear him on merits, right?
Yes, my lords.
Presently, you are saying that all this action should be taken at the first.
Yes, my lords. I rely upon two judgments of the Supreme Court.
Yes.
My lords, 1995 2 SCC 130.
1995.
Yes, my lords. Supplement 2 SCC 130 para 7 and 8.
130 para. Yes.
Para 7 and 8. My lords, I'll read those important paragraphs, my lords.
Criminal contempt.
Any reference in the course of justice, any obstruction caused in the path of those seeking justice are an affront to the majesty of law and therefore the conduct is punishable as contempt of court. Law of contempt is only one of the many ways in which the due process of law is prevented from being perverted, hindered or thwarted to further the cause of justice. Due course of justice means not only any particular proceeding but broad stream of administration of justice. Therefore, due course of justice used in section 2C or section 13 of the Act are of wide import and are not limited to any particular judicial proceeding. Much more wider when this court exercises suo motu power under Article 129 of the Constitution. Due process of law is blinkered by acts or conduct of the parties to the litigation or witnesses which generate tendency to impede or undermine the free flow of the unsullied stream of justice by blatantly resorting with impunity to fabricate court proceedings to thwart fair adjudication of dispute and its resultant. If the act complained of substantially interferes with or tends to interfere with the broad stream of administration of justice, it would be punishable under the act. If the act complained of undermines the prestige of the court or causes hindrance in the discharge of the due course of justice or tends to obstruct the course of justice or interfere with the due course of justice, it is sufficient that the conduct complained of constitutes contempt of court and liable to be dealt with in accordance with the act. It has become increasingly a tendency on the part of the parties either to produce fabricated evidence as a part of the pleading or record or to fabricate the court record itself for retarding or obstructing the course of justice or judicial proceeding to gain unfair advantage in judicial process. This tendency to obstruct due course of justice or tendency to undermine the dignity of the court needs to be severely dealt with or deter the persons having similar proclivity to resort to such act or conduct. In an appropriate case, the mens rea may not be clear or may be obscure, but if the act or conduct tends to undermine the dignity of the court or prejudice the party or impedes or hinders the due course of judicial proceedings or administration of justice, it would amount to contempt of the court. The acts of the respondent in fabricating the court proceedings purported to be dated 9th June 1992, impersonating himself to be the petitioner and producing the fabricated copy of the court proceedings in the office of the District Inspector of Schools does constitute contempt of the court. It tends to interfere with the course of justice in legal proceedings to gain unfair advantage over the petitioner and is not innocent as pretended to be by the respondent. Further, as we have already held that alone stands to gain by fabricating the court proceedings and producing it before the authorities for his continuance as manager of the school. He had the necessary animus or mens rea to fabricate the court's proceedings, impersonated himself to be the petitioner, and produced it in the office of the District Inspector of Schools. Para 8, the question then is whether his apology would be acceptable or is liable to be punished. it is seen that his apology in the counter to the show cause notice is only conditional and not an unconditional one. Public interest therefore demands when a person had interfered with the judicial process and fabricated the court's proceedings, impersonated himself to the petitioner and produced in the office of the competent authority so as to enable him to continue as a manager of the school, the judicial decision should not be preempted or circumvented by mere statement of a conditional apology or as a fact even unconditional apology. The unconditional apology should be contrite for the acts committed by him. Therefore, the conditional apology would not be a premium to avoid conviction. Though it is open to the court in an appropriate case to accept an unconditional apology based on factual scenario, but accepting the apology, dropping the proceedings of contumacious acts deliberately done to overreach the due process of the law without compunction would amount to a premium to fabricate the court order with impunity. In Asharam versus Jain, A.T. Gupta, the petitioner made scandalous allegations against the Chief Justice of the High Court and without withdrawing those allegations, offered an unconditional apology. This court did not accept the unconditional apology and imprisonment and convicted the contemnor for contempt and sentenced him to 2 months imprisonment to atone him for his contumacious conduct. Therefore, we have no hesitation to reject the respondent's conditional apology. In view of the facts set out herein before and the findings recorded, it is a grave and contumacious act and the conduct on the part of the respondent which cannot be lightly brushed aside. Therefore, we are of the opinion that it is a fit case that the respondent should be convicted and accordingly convicted under Article 129 of the Constitution and sentenced to undergo rigorous imprisonment for a period of 3 months. The suo motu contempt petition is accordingly ordered. While at the other judgment of the Honorable Supreme Court, 1995 1 SCC 421, paragraphs 3, 7, 8 and 14. 1995 1 SCC 421. I have furnished the copy of the input. Paragraph 3, my lords. Paragraph 3, 7, 8 and 14. Para 3. Para 3, my lords, I am reading. These prefatory remarks will project the importance of the point under consideration in suo motu contempt action taken against respondent Anil Kumar for his having filed a fabricated document to oppose the prayer of his wife seeking transfer of a matrimonial proceeding from Delhi to Unnao. It shall be first required to be seen whether Anil did file a fabricated document, and then we shall address ourselves as to whether filing of a forged document with intention to defraud amounts to contempt of court, as this expression has been defined in section 2 of the Contempt of Courts Act. But the next paragraph of the judgment 7, 8 and 14. 7. There being no decision of this court or for that matter of any high court to our knowledge on this point, the same is required to be examined as a matter of first principle. Contempt jurisdiction has been conferred on superior courts not only to preserve the majesty of law by taking appropriate action against one, howsoever high he may be, if he violates court's order, but also to keep the stream of justice clear and pure, which was highlighted more than 2.5 centuries ago by Lord Hardwicke, LC in St. James Evening Post case, so that the parties who approach the court to receive justice do not have to wade through dirty and polluted water before entering their temples. The purpose of contempt jurisdiction was summarized as below by Lord Morris in Attorney General versus Times Newspapers Limited. In an ordered community, courts are established for the pacific settlement of disputes and for the maintenance of law and order. In the general interest of the community, it is imperative that the authority of the courts should be imperiled and that recourse to them should not be subject to unjustifiable interference. Such an unjustifiable interference is suppressed. It is not because those charged with the responsibilities of administering justice are concerned for their own dignity. It is because the very structure of ordered life is at risk. If the recognized courts of the land are so flouted, their authority wanes and is supplanted. 8, my lord, to enable the courts to ward off unjustified interference in their working, those who indulge in immoral acts like perjury, prevarication, and motivated falsehoods have to be appropriately dealt with, without which it would not be possible for any court to administer justice in the true sense, and to the satisfaction of those who approach it in the hope that truth would be ultimately prevail. People who would have faith in courts when they would find that Satyameva Jayate is an achievable aim. There are Yate Dharmaste Jay is not only inscribed in emblem them, but really happens in portals of courts. The last paragraphs of the judgment, paragraph 14. The legal position thus is that if the publication be with intent to deceive the court, or one made with an intention to defraud, the same would be contempt, as it would interfere with the administration of justice. It would in any case tend to interfere with the same. This would definitely be so if a fabricated document is filed with the aforesaid mens rea. In the case at hand, the fabricated document was apparently to deceive the court. The intention to defraud is writ large. Anil Kumar is therefore guilty of contempt. My lords, my respectful submission, even after securing the order, my lords, when they produce certain documents, my lords, showing that some tax has been paid to the Gram Panchayat. My lords, even the state of Telangana was not existing at the time, my lords, when the certificates themselves are, my lords, fake. Therefore, my lords, it is not that he is unaware of those fake orders. My father has kept the records. I have filed based on such records. My lords, it is apparently, my lords, a fraud on the court, a deception. Such a thing, my lords, cannot be countenanced at all, and no concession of whatsoever for such type of litigants, my lords, be considered. I therefore request, my lords, your lordships to consider to direct the registry to lodge a complaint and take action under the contempt of court, that is to criminal contempt. I am grateful, my.
My lord, though I am the petitioner, the learned Advocate General has completely presented a case of the petitioner in such a manner that the petitioner is a person who has played fraud on the court. My lord, it is necessary to see what exactly is the case about. First item, my lord, item number 208 is writ petition number 7859 of 2023, which is the lead matter. It's a writ petition filed with a prayer that the respondents, that is HMDA and police, should not interfere with the possession of the petitioner over the subject land without following the procedure of law. This is the nature of the writ petition. And in this writ petition, there was an interim order passed by the learned judge, because this has gone before the learned single judge. The interim order is both parties are directed to maintain status quo. Despite the status quo order, there is a disobedience of the status quo order complaint in the next two matters, which are contempt cases arising from out of the status quo order passed in the same writ petition 7859 at 43.
When was the interim order passed? Date?
I have, today morning, I have circulated a list of dates and synopsis also for the convenience of the Honorable Court in USR number 111154 of 2023. Or I may pass on again, right?
Date of, we are only want to know what is the date of interim order?
The Interim order is passed on 20th of March 2023. And while passing the interim order, the writ petition is directed to be placed before the special bench because it is connected to CS number 7. Therefore, in my respective submission, your lordship may kindly hear me on my main writ petition.
Now, what about this non-existent orders and this?
No,
They are existing according to you.
there are 3 orders which are filed along with the writ petition affidavit. One is a sale certificate, which is filed as Exhibit P1 in the writ petition. Sale certificate issued in CS number 7 dated 27/4/1968, which is a certified copy of the court. Then the second is the copy of the order in WP number 35966 of 1997, dated 28/12/1998, which is a typed copy which is filed. It is not a certified copy and it is not one which is issued by the court. It is a typed copy maintained along with the petitioner, which he has filed, and that is Exhibit P2. And the third one is Exhibit P3, that is certified copy of the order passed in application number. Certified copy of the application number 342 of 1992.
Another order is of the same date passed in a different rate petition, right? 35970.
25970, is not the present.
So like only exhibit P2 is there, 28/12/98.
That is the only order.
Order.
Yes. That is the only order, in respect of which the registry has submitted a report stating that neither the filing register of this WP number 35966 of 97 nor the order sheet or the orders passed by the learned judge available with the registry, which are in the manual form, are traceable.
What do you say?
No, I have not filed any certified copy of that, I have filed a typed copy of the order, and I have stated that this copy was available with the father of the petitioner and in the office, and it is filed as it was available, believing it to be true. And at any rate, on the merit of the case, that order is not the basis for the relief that is claimed in the present writ petition. The 2 orders on the basis of which this prayer in the writ petition that the respondent should not interfere without following the procedure of law they are based upon the sale certificate, which is a certified copy dated 27/4/1968 and 27th April 1968 and certified copy in application number 342 of 1992 in CS number 7 of 1958, which is also available in the registry. Certified copy, in fact, I have brought to the court today the certified copies of these 2 orders.
Which order?
For this, one is sale certificate. Second is the order copy, that is copy application number 342 of 1992, dated 4/9/1992. If my lord permits me, I will just pass on these certified copies for the perusal.
No, the only thing is about this order, which admittedly, which is not like, you are not saying that it exists.
No, I am not saying that it is existing. I said that I have filed on.
You have got the type copy from your father personal record and you have filed it.
In the files, this particular order was available. It is not a certified copy.
Certified copy.
It is only a true copy.
True copy.
Paper copy. And that is filed, and that is also shown as there is absolutely no suppression, that is Exhibit P2. If takes the writ petition material paper sponge, they are all there. In this writ petition 7859 of 23.
Page
The sale certificate, my lord, is at page
14.
number 14.
Ah.
The legibility, my lord, is poor. I have got the certified copy of the High Court issued by the High Court of Telangana. So that order was.
This is not in dispute, right? Nobody is
They are saying, my lord, that this order is also not genuine.
No, he did not.
And it cannot be relied upon by the petitioner.
No. He didn't say argue this about sale certificate. You didn't say anything.
My lords, sale certificate and the order which my friend is referring to.
You did not say.
I did not, because they are there. My lord, they can be dealt with in the, when the your lordship takes up the hearing on in the writ petition. But before that, my lords, this order in 35966 of 9.
That's what.
My lord, this is placed reliance in the affidavit. It's a statement of the deponent.
Yes.
The reliance has been placed, that has been referred to in the report.
All right. So this, they are not saying exhibit P1 sale certificate.
Their additional counter affidavit, my lord, they have given a tabular statement, my lord, disputing all this in the record. And in the additional counter affidavit, the last para says that possession of the subject property may be restored to them. But the prayer is that the petitioners are in possession. They should not be dispossessed or interfered in accordance with law.
Right.
Their additional counter affidavit, after the registrar judicial submitted the report, they have come up with additional counter affidavit where the prayer is the Honorable Court may direct restoration of the possession of the subject land to HMDA. This is the affidavit filed, my lord, after this correctness and genuineness of this particular order is raised before the Honorable
Presently,
Court.
we are hearing you on the submissions which they have been made that this is forged document and this filing it amounts to criminal contempt, and the two submissions made that this court should direct the registrar to lodge a first information report and contempt for proceeding for criminal contempt should be initiated. That's what we have understood. So, what do you say with regard to this?
Unless and until it is found from the order, your lordship may kindly have a look at that particular order. That is,
you could have only relied on the sale certificate and got away with such an order, right? Not
sale
this.
certificate also, my lord. Drafting is different by different advocates.
Yes.
All cannot draft alike.
Yes.
The answer they have stated some unnecessary. They thought, my lord, it's a supplementary fact in their favor. They, my lord, kindly see the index of the material papers in this writ petition at the page 7859 of 23.
Yes.
Material papers. These are the material papers relied upon.
We have got.
One is sale certificate.
All right. Yes.
Second is copy of the order in WP 35966 of 1997 dated 28/12/98. Then copy of the order in WP number 5418 of 2021 dated 4th March 2023. Then copy of the petition in contempt case. That is not much relevant, my lord. Property tax assessment notices. That is that to show possession. Then serial number 12, my lord, copy of the order in application number 342 of 92 dated 4/9/1992. Then thereafter, my lord, copy of the, that is Aadhaar card, family member certificate, photographs, Kalatnama. These are the documents and the affidavit in the writ petition. At page number 7. The writ petitioner's name, well, this name plays a crucial role in this case. The name of the writ petitioner is Yahya Qureshi, son of Muhammad Farooq Qureshi. And in the body of the affidavit, at page number 8, para 2 describes the details of the scheduled land, that is subject land, survey numbers 725/21, 725/23 and 725/24 at Shamshabad village. I'll repeat, the subject property is survey number 725 by 21, then 725 by 23, and 725 by 24, situated in Shamshabad village, Rangareddy district. Then paragraph number 3. How the petitioner has narrated his case, my lord, I would like to read, my lord, that. I submit that my father was the absolute owner and possessor of the land at measuring 7 acre 31 guntas in survey number 725 by 21, that is 10 acre 7 guntas, 725 by 23, that is 12 acre and 24 guntas, and 725 by 24, situated in Shamshabad village and Mandal, Rangareddy district, having purchased the same under sale certificate dated 27/4/1968, issued pursuant to the order passed in application number 335 of 1962 in civil suit number 7 of 1958. Since the date of purchase, my father was in peaceful possession and enjoyment of the subject property without any disturbance from any corner. I submit the then Hyderabad Urban Development Authority tried to interfere with my father's peaceful possession over the subject property under the guise of Land Acquisition Award number 1 of 1990 in file number 84 of 1986, dated 2nd January 1990. And my father filed WP number 35966 of 97 on the file of this Honorable Court, and the Honorable Court by order dated 28/12/1998 was pleased to set aside the award number 1 of 1990 in IA number, that is LA, not IA, LA number 84 of 86 dated 12/1/1990, and matter remanded back to the respondents for fresh inquiry, and further directing the respondents to issue fresh notice to the petitioner therein, and upon such notice received by the petitioner, petitioner is free to file objections if any, and the authorities concerned are directed to pass such fresh orders if they so please, strictly in accordance with the provisions of the Land Acquisition Act, and further directed the respondents not to interfere with the petitioner's possession over the subject land till passing of fresh order by the respondents. I submit that till date the respondents have not issued any fresh notice to my father or to me as directed by the Honorable Court in WP number 35966 of 97, and the order passed by the Honorable Court in WP number 35966 of 97 has become final, and my father's name was also entered corrected in the connected revenue records. I submit that subsequent to my father's demise, I have succeeded to subject property, and my name is also mutated in the revenue records, and I have been in continuous possession and enjoyment of the subject land by constructing a watchman room and fenced compound wall. I have got assessed the property by the PTA number so and so and paying property tax. Para 4. I submit that when the respondents tried to interfere with my possession over the subject property in the month of March 2021, I filed WP number 5418 of 2021, about which there is no controversy, and this Honorable Court was pleased to dispose of the writ petition by an order dated 4th March 21. The operative portion of the order is extracted below. And after that extract, para 5, I submit that in spite of specific direction order in dated 4th March 21 passed by the Honorable Court, respondents tried to interfere with my peaceful possession and enjoyment in willful violation of the order dated 4th March 21. As such, I filed contempt case number 334 of 2023 before the Honorable Court. Same is pending adjudication. I submit that while being so, on 18th March 2023, the respondents herein, once again, along with men and machinery, came to the subject property, started demolishing the compound wall. The respondents herein, with the help of local police and the Assistant Director Survey Settlement Land Record, is trying to take possession of the subject property without issuing any notice to me and without following due process of law. I submit that I am in possession of the subject property only. I have not encroached an inch of land pertaining to the respondents. The respondents, under the guise of survey number 725 by 22, he is not claiming this merit, 725 by 21, 725 by 23 and 725 by 24 are the subject lands now. This is another land, adjacent land, 725 by 22 being HMDA, that is Huda earlier, trying to take possession of my private patta land in survey number 725 by 21, 23, 24. The respondents herein till date have not issued any notice to me under law. Even the alleged survey as submitted by them. With great difficulty, we could resist them and showed them all ownership documents and orders passed by the Honorable Court. The Honorable Court efforts put by me went in vain. If the petitioner is dispossessed from the lands, the petitioner will be put to irreparable loss and severe hardship. Therefore, the petitioner is constrained to approach the Honorable Court. Then the prayer portion at paragraph number 10. The petitioner prays the Honorable Court may be pleased to issue appropriate writ order declaring that the action of the respondents in interfering with the petitioner's peaceful possession and enjoyment of the property 7 acre 31 untas in survey number 725 by 1, 725 by 21, 725 by 23 and 24 situated at Shamshabad without there being any authority, without following due process of law as arbitrary, illegal, contrary to the provisions of the Land Acquisition Act 2013 and violation of Article 21 and 300A of the Constitution of India, and consequently direct the respondents not to interfere with the petitioner's peaceful possession and enjoyment of the property at measuring 7 acre 31 guntas in survey number so and so without following due process of law. This is the entire affidavit made in the writ petition. And the enclosures include this order. Only one order is the controversial order, that is at page number 17. You will also may kindly see only page 17. Kindly see the neat copy at page 18. 17 is not legible. This is in the High Court of Judicature, Andhra Pradesh, Monday, 28th December 1998. The WP number 35966 of 1997 between Mohammad Farooq Qureshi, father of the petitioner, and district collector and 3 others. It was manual days. The computerization was not there. There was no full description of the cause title. Then at the next page, page 19, the order runs. Heard the counsel for the petitioner and the counsel for respondents. The counsel for the petitioner stated that the petitioner is the absolute owner and possessor of the land at measuring 9 acre 31 guntas, survey number 725 by 21, 10 acre 7 guntas in 725 by 23, and 12 acres 22 guntas in survey number 725 by 24, situated at Shamshabad village Mandal, Rangareddy district. By virtue of the sale certificate by the Honorable Court in application number 335 of 1962 dated 27/4/1968, and possession was also delivered to the petitioner, and the petitioner is in possession and enjoyment of the same. And at the time of passing of the award, no notices were issued to the petitioner, and award number 1 of 90 in file number LA 84/86 dated 12th January 1990 was passed by the respondents behind the back of the petitioner, full stop. No counter affidavit filed by respondents, and the counsel for respondents appeared and stated that the petitioner may be directed to receive the notices under the LA Act, and the notices may be served to the petitioner, and the petitioner is directed to file their objections for fresh inquiry. The particular further submit that physical possession of the subject lands were not taken and compensation has been paid to the
No compensation.
No compensation has been paid to the petitioner and the acquisition proceedings and the award shall be deemed to have lapsed. In view of the submissions, the award dated award 1 of 90 in file number so and so dated 12/1/90 is hereby set aside and the matter is remitted back to the respondents for fresh inquiry and directing respondents to issue fresh notice to the petitioners. Upon such notices were received by the petitioners and the petitioner is free to file objections if any, and the circumstances concerned are directed to pass fresh orders or if they please strictly in accordance with the provisions of the Land Acquisition Act and duly following the procedure prescribed under the Act. And the petitioner further is stating that he is in possession and enjoyment of the land and possession is not yet taken by the respondents. Therefore, the petitioner is seeking a direction directing the respondents not to interfere with possession of the petitioner land. Therefore, this court is directed the respondent shall not interfere the petitioner's land till passing of fresh orders by the respondents. With the above observation, writ petition is allowed. Then bottom mallet, copy to the district collector, Rangareddy district 2, the project director, acquisition officer, Rangareddy district, then the revenue divisional officer, then 4th, the Hyderabad Urban Development Authority office at Rasulpura, Begumpet, Hyderabad. Copy to Wasi Muhammad advocate. Well, at this order, the petitioner Malad has not filed any certified copy. My comments on this first submission is this. This order, which is filed as a document in the list of documents in the writ petition, in WP number 35966 of 97, is only a copy of the order, but it is not containing seal of the Honorable Court. It is neither a certified copy nor a carbon copy of the order. And petitioner's explanation about the non-availability of this order in the registry of the court is that this order was available in their house, in the residence, and this particular true copy was taken out and filed in this particular writ petition. Therefore, there is nothing which is added or which is made up or put up or fabricated insofar as the order is concerned. But one small submission at this stage. The report of the registry says that there is no writ petition with the number WP number 35966 of 97. When at writ petitions, when they are numbered, the numbers are given in the serial order. The registry further says there is a writ petition record of 35965 of 97 and there is a record of writ petition 35970 of 97.
3596?
35965. One matter before this number, that is 35966 melody is this order.
Yes.
35965 of 97 record is available and 35970 of 97 record is available. And since the record was shifted 3 times as per the report of the Honorable Judicial Registrar, 3 times it was shifted to different places, the manual registers are not traceable. But if this order, I put a question to myself, if this order is one which the petitioner has prepared and the number of the writ petition is 35966 of 97, then as per the record or registry, there must be one writ petition with the number 35966 of 97 not pertaining to this subject matter, pertaining to some other subject, petitioner being different, respondent being different, because there is no possibility of jumping of the number from 35965 to 35970 when 35966 of 97 is intervening in the middle. Then the learned advocate general has also not submitted that this WP 35966 of 1997 relates to some other matter not concerned to the petitioner, and the petitioner has changed the order in the court and then has placed an order which is advantageous to him. Assuming, my lord, that this is a service matter, the order would be something totally different between different parties. That order is replaced and this order is inserted to give strength to the case set up by the petitioner. That is not the submission made at all. And the registry says that there is no number 35966 of 97 available as per the filing register, or also orders passed by the learned single judge whose name is reflected here. So petitioner has only produced a true copy of this order, and the petitioner cannot be said to have produced either a fake order or a fabricated order of this particular number, WP number 35966 of 1997. And at any rate, this order actually is not the foundation for the claim of the petitioner in the present writ petition. Here, I beg to request your lordship's attention to page number 41 of the same material papers. That fits up. Millet, may I have the permission to pass on the certified copy of this order, Millet, to the Honorable Court. The original certified copy issued by the court. This page 41 order. Millet, the certified copy is the one which I have just now passed on to the Honorable Court. This is in application number 342 of 1992. I have only one certified copy, Millet. I do not have two copies. Will also apologize me for not supplying the second copy. Then here the additional counter affidavit filed by HMDA states that, and is
So in the order what you have now submitted, the first page has application number 342 of 1992.
Yes.
There must be a reference to a CS. And the next page, there is a reference.
No, that is referred in the next page, Millet. You will also may kindly see before the order starts.
It can't be. The first page should have the application and the number of the CS. This page is apparently different to this, the second page, which has a reference to the CS. No, to our understanding, because we have been seeing orders day in and day out.
No, the orders, Millet, certified copy, public document, Millet, a order supplied by the court to a litigant. Millet is a public document under section 74. The order has to be seen as it is because there is a presumption under section 79 of the Evidence Act about the order. And the manner in which now the criticism, Millet, is not about that particular Millet. Kindly see page 41 itself, the first page itself. The application number is 342 of 1992, but the order date, which is in words, is Friday the 14th day of September 1990. The contention raised by HMDA is that when the application is of 1992, how order could have been passed in the year 1990, 2 years prior to the filing of the application. That is what is pointed out in the additional counter affidavit. And as far as the drafting of the order is concerned, you will may also see at page 41 as to who are the petitioners and respondents. That is, Nawab Muhammad Wajihuddin Khan is the applicant. And in the respondents, my lords will find fourth respondent, the Hyderabad Urban Development Authority office at Rasulpura. No, I am showing this only to say that this order is not one which is made or manufactured by the petitioner. This order is the Xerox copy of the certified copy issued by the court.
So when this copy?
That is this. Even today, my lord, the original is also available in the registry, my lord.
Delivered no date. 21.
Copy is copy है भाई इसमें जो दिए हैं उसमें. My lord, there is an endorsement like this copy when applied and when given,
Yes,
that is
yes.
there on that also.
We have seen that.
Yes. And this is issued by the state of Telangana, my lord. This order was passed long ago in Andhra Pradesh state. And I pray my lords to kindly see the substance of this order. At running page 43. Heard the counsel for the petitioner and the counsel for the respondents. Counsel for the petitioner stated that the applicant is the absolute owner possessor of land at measuring 10 acres in survey number 725/5. The extent, Millet, there are many extents, Millet. All those survey numbers I will just skip because your lordships will find from the bottom sixth line, total extent of land is 216 acres and 2 untas. From the bottom, Millet, sixth line. Further, stating that the compensation neither paid to the applicant who acquired the property in the said village by virtue of the allotments made by this court, nor to the Nuzuldars of the Paiga, namely Farooq Qureshi. Farooq Qureshi is the father of the petitioner, Muhammad Yunus Khan, another person, and Muhammad Tajuddin, who obtained sale certificate from this court in the above suit and in possession of the subject property in the said villages and physical possession of the land has not been taken over by the state. Applicant further stating that the concerned respondents, being party in the above suit, are well aware of the ownership and belongs to Paiga as per the revenue record classer register 1354 firstly in the year 1944 AD before proposing the subject property for acquisition for truck terminal in Shamshabad village before proposing the subject property for acquisition for truck terminal in Shamshabad village. There is a repetition of the sentence, the subject property, without entering into the question of possession of the landed property in the said village. Respondents passed the award. Hence, the applicant files the application seeking to quash the proceedings of the LA and not to interfere with the applicant position till fresh land acquisition proceedings are initiated. No affidavit filed by the respondents, and the counsel for respondents appeared and stated that the applicant may be directed to receive notices under the LA Act and notices may be served to the applicant, and the applicant has liberty to file objections. In view of the submission, the court observed that at no point of time after preparation of the award, notice was served to the landowner, and hence it is held that since the physical possession of the land has not been taken over and the compensation has not been paid to the owner, the acquisition proceedings shall be deemed to have lapsed. The award proceeding 1 of 1990 in file number LA 84/86 dated 12/1/1990 hereby quashed as authorities fail to take physical possession of the land and any compensation as required under LA Act 1894. The court further directs concerned respondents, if pleases, shall initiate a fresh acquisition proceeding according with the provisions of the Act, and the respondents are directed not to interfere with the petitioner land
without following
due process of law. With the above observations, the application is allowed. It may be perhaps strange that application is filed instead of filing a writ petition. Learned Advocate General has argued that land acquisition proceedings will be challenged in a writ proceeding. But against this order, even after the present writ petition has been filed, it could have been possible, because this certified copy still exists. Against this order of the learned single judge, an intra-court appeal lies before my lords only. This order could have been challenged by them at any length of time, or at least even now. But this did not happen. And this order has remained in its place. And the original order, is in the registry. It is available for the perusal of the Honorable Court if it is summoned from the custodian of the original record. Then, after the Honorable Court has passed the order directing the Registrar Judicial to submit a report,
yes,
an additional counter affidavit has been filed by the respondents. Your Lordship may kindly take that additional counter affidavit.
We'll continue on Tuesday, Mr. Right? Mark the, yes.
No, because the learned Advocate General said that the petitioner should be immediately prosecuted, criminal prosecution and contempt. I thought I will have to complete my argument today itself, Merit. I thought so.
No, good that you have argued, right? Yes. So we will whatever orders follow.
Yes, will follow.
You have given this your explanation that.
I can only give my explanation.
Yes,
but I thought I will have the first chance, but he has taken it.
No, he has not argued anything on merits. You are telling us everything. We didn't see this.
Before we close this case today, only 1/2 second. In the additional counter affidavit, only see last 2 lines.
They are demanding possession from you.
Restore
possession.
Restore possession to HMDA
yes.
from the petition.
My lords, under the, my lord,
All right.
under the order.
No, I am not saying anything further.
No. We will continue on Tuesday. Further hearing, it will come up in the first half itself.
Yes. Oblige.
Mark the presence. This one. Wait, madam, send this. Mine. Please, okay. One.
May I make one small request?
Yes.
Because the manner in which that number in application 342 is mentioned, that original application may be summoned from the registry before your lordships on the next date. I have ordered a certified copy. I have placed certified copy.
Yes.
The original also.
Let office is directed to produce the original record of the proceeding in which order aforesaid order dated so and so in application number 14. Yes.
My lord, I have issued the counter today itself, your lordship, filed by the respondent 4 and bundled yesterday. So kindly seeking time, your lordship, with this.
You are for the petition.
Your lordship.
Your lordship may kindly see, Lord. Lord, this honorable court.
You are appearing in that CS matter. No.
My friend, my friend.
So you have just now filed a counter, right?
Yes.
No,
where the order passed by Supreme Court is being misused as if Millard is in possession, you making further construction. The order was Millard to not to demolish. Order is only not to demolish. By
You
virtue of
don't
this
raise
order,
any construction. Don't raise any construction.
Lordship, please to observe. Millard.
Yes, yes.
Of this interim order, he wants to now present to take possession of the property.
No, my lord, that is not true, your lordship.
We erected blue sheets around the land.
3 weeks may be granted, your lordship.
24th November.
Yes.
24th November.
Interim order may be extended.
Interim order be passed, right? Just now.
May I please? Matter pertains to non-registration of mortgage deed in.
Yes, Mr. Next Friday. Next
Friday.
Friday. There's no time left today, Mr. You will appreciate. List on next Friday.
So
What
far
is
as
the
I
date list on? Say.
undertaking affidavit. I filed Millard under USR number that can be placed on it.
Yes. No, we must be there, no? Is it there, madam? It's there.
Much of.
Next Friday.
I beg to appear in this matter, Your Lordship.
Next Friday, 17. List on 17, 11, 20.
215 and 216, Millard, your lordship may kindly have it on 24th, Millard. Senior counsel is appearing on that day.
Learned counsel for the petitioner. That I made notes. Keep it there. 24th November.
Yes, on request, Millard, your lordship's direct appointed Millard receiver in this CS 14. Millard report, Millard, August, Millard, receiver was appointed. Report was not filed, Millard. Lordship may direct the registry, Millard, to inquire about the report, Millard. Status of.
The registry shall next on 24th. 24th.
Receiver report, Millard, if Millard.
It will come eventually.
24th we will see.
Registry can inquire, Millard. With the receiver,
Find out on 24th.
Much of it.
Hmm? Yes. What happened? Nobody's, this is contempt. Huh? Who? So shall we, what, pass over? What, or next Friday? Next Friday. Yes, madam. A respondent has been served. Nobody appears. Notice has been served. None for parties record peruse. This petition has been filed. Survey notice served. Right, this petition 11/6. Served, nobody is opposing you. Served, all right. So then, what is it? What is the quantum like amount? All right. Right, same thing. We will appoint some former district and session judge. Ah, hmm. Oh, not the best. Who? All right, same order. All right, disposed of. First time. Learned Counsel for Respondent praise for his granted. Hmm. Absent. Not interested, right? Huh? Huh? Not interested, no? None had appeared on behalf of. Huh? Why? Hmm. All right, none for the. So, what? There is no arbitration clause, right? Then, what pleading complete? This is not a this thing, Mr. Ray. Yes, ready? Huh? Ah, You will have to demonstrate that the stamp duty has been paid in accordance with
law.
That's it.
Yes. Yes,
If you, otherwise, then only we will go to second issue. Otherwise,
Yes.
you know what is the result.
Yes, my lords. We
Constitution
understand
means
Indian
what
global
are
is
the-
there, my lords. My lords, what we have done, my lords, is with the rejoinder, we've filed, my lords,
Just give a chart, Mr. What is the stamp duty payable? Which article? How much have you paid? That's all.
my lords, according
That's
to us, under Article 6A, my lords, 200 rupees is payable.
Article?
Article 6A of the schedule to the Telangana Stamp Act.
You are ready, Mr. Schedule?
Schedule 1A, my lords. Article 6, capital A, Roman number 3, my lords.
Agreement, memorandum of agreement, where the value
Yes, my lord.
exceeds 20,000 does not exceed 50,000.
3, my lords. Row number 3, where it exceeds rupees 2 lakhs.
In my, some updated version of the book, in our copy it says exceeds 50, 3 exceeds 20,000, does not exceed 50,000.
There is an
Rupees
updated
200
version.
for value exceeding rupees 2 lakhs.
Value exceeding 2 lakhs is 6A3, my lords, which is what I have, which I've just downloaded from the Telangana's registration and stamps website.
You see this, what like
That might be old.
old?
Lords, I just.
No, yeah, so what like
It's 200 rupees, my lords. The stamp duty payable is 200 rupees.
for that's 4.
Yes. In the amended version, there's only 3. They've replaced that with 6A3.
It has been amended with effect from 23/7/2015, right? An agreement where the value 6A3 is in this book. Please see how. Madam, yes, give it. Another copy, page 98.
Telangana.
98, please see. Page 98, Mr.
98.
Schedule 1A, Article 6.
6A.
6A, Roman 3. What does it say?
It says exceeds 20,000.
Ah.
Yes.
What, where are you getting this thing version?
Online now. There 3 like 2, 3. My lords, in basically, my lords, 6A4 as per this will apply to us, my lords.
So then you are saying 3, that's the confusion. 4 is clear.
It's different in the website, my lords. I'm sorry, my lord.
No, 4 means exceeds 50,000.
Exceeds
So
50,000.
like 200 for value exceeding 2 lakhs.
Yes.
What is the value?
It's 200, my lords. Exceeds in that, as per that schedule, my lords. Value exceeding 50,000 is 200 rupees. There is no other provision for exceeding 2 lakhs in that.
It's an agreement. All right. Yes. What's your objection? Let's understand from him first.
Yes, my lords.
Then perhaps you can respond.
Stamp duty is rupees 200, my lords. And as your lordships have said, my lords, it has to go through the procedure for sending it to the concerned department. My lords. They have to, whether the impounding and penalties
No,
up to
200 he has paid, no?
No, my lords. He has not paid any. Stamp duty is not paid at all.
Oh.
On the original agreement, my lords, I was coming to that. On the original agreement, when the agreement was executed, it was not paid. But my lords, may I just pass on an order of the Bombay High Court, where my lords, the Bombay High Court, no, my lords, just for a minute, my lords.
What
With the rejoinder, my lords.
minute?
Yes.
Constitution bench judgment of Supreme Court. You first tell us.
There is no dispute that the stamp duty has to be paid, my lords. I'm
Then
not.
it has to be impounded.
No, my lords, there is an alternative procedure. May I just, my lords?
2000, which 23, volume 7 SCC, page 1, Constitution bench judgment.
Yes, my lord.
Yes, my lords, the NL Global, I'm aware, my lords.
NL Global.
My lords,
How can you argue contrary to decision?
No, I'm not arguing contrary. I'm not
It has to
arguing.
be impounded and has to be sent. We can't
My
do
lords,
anything.
on that point, my lords, may I just rely on this judgment, my lords. Just 1 minute.
First you tell us, it's your duty to
Stamp
tell us.
duty, stamp
this
duty
is
has
what-
to be paid. Otherwise, my lords,
Mister, you started as if the document is sufficiently stamped.
lords-
This is what, this is what
I was
we are
just
telling you.
coming to it.
Just a minute. This what you should have said that it has, this stamp duty is 200 rupees. Second sentence, it has not been paid.
No,
And
my
third
lords, I'm
sentence,
just-
I am relying on Bombay High Court judgment.
No, my
Even
lords-
though Constitution bench says otherwise.
No, my lords, that's
The
not.
Bombay High Court does not bind us.
I'm
We
not
have
saying
no
not
confusion
pay the
about
stamp
it.
duty, my lords. My lords, with the rejoinder, my lords may take a rejoinder for a moment. We paid the stamp duty, my lords. That's what I'm saying.
That's what they are trying to do now, my lords. With rejoinder, they have filed 200 rupees stamp duties. Stamp
Yeah,
paper.
we should pay it here, like it should be deemed to have
Yes,
been
my lord.
paid.
That's what
No,
they're
my
trying to say
lords,
now.
which is the reason, my lords, my lords may take the rejoinder for a moment. We paid it with penalty 10 times.
It's 2023 SCC online SC 49.
This 23 volume 7. Please read.
I'm not disputing that for a moment, my
Please
lord.
read what should the court do. I mean, we want to know how this thing is, this sort of is course of action.
My
which
lords,
you are seeking is permissible. That's what
it's
is the query.
permissible under the Stamp Act, my lords.
Oh, where is it?
My lords may have section 35, my lords, of the Stamp Act.
Achha, first, what this thing Constitution
It
bench has-
doesn't necessarily have to be impounded, my lords. May I just read?
No,
my
no.
lords?
What has the Supreme Court said?
My
Will you
lords,
tell
the
us
Supreme Court has said that if stamp duty
Where?
is not paid,
where? You haven't got, right? Let's
no, I haven't.
argue next week.
My lords, I have the
Learned
my lords.
counsel for the respondent has submitted.
For the respondents, we filed our counter.
I beg to appear in this.
Two-
I did for the response.
231. Which case?
I beg to appear
231.
in this matter, my lord.
Ah,
Having served a copy of counter today in the afternoon, my lord.
ah.
Kindly 2 weeks time may be granted, my lord.
Why?
In the afternoon only, I received the copy of the counter.
So next week you can argue, right? This is 11/6.
My,
We are not asking you any
as a lordship basis.
learned counsel for the petition. Yes, okay.
I'm obliged.
2 weeks, list after 2 weeks.
232 to 238 go together, my lord. It's identical issues, my lord. There is an arbitration clause in letter of intent. The issue is, my lord, whether from which period the authorization period has to be considered. Your lordship may come to page number 182, my lord. 182. This is a request for proposal. Request for proposal.
What are the facts like?
Well, the facts are, my lord, GHMC floated a tender for construction and maintenance of a footover bridge, my lord. Footover bridge. And, my lord, we were entitled to invest the money, construct it, and then exploit it as an advertisement. But not the advertisement, footover bridge. Accordingly, an agreement.
Who appears?
I appear for the.
We filed a counter.
You are appearing
Yes,
for
we filed
ready, no?
Yes, ma'am, I'm ready. Yes.
But agreement was entered on 5th October, my lord, in this case.
5th October?
5th October 2017, my lord. Prior to that, there was been
Which clause contains an arbitration?
LOI contains, my lord. LOI contains.
So this is not LOI. 15.
No, that's what. First, my lord, it started with a request for proposal, my lord.
No, 510 is agreement, you said no.
So LOI is also part of the agreement. LOI is also part of the agreement. My lord. Arbitration clause is contained in LOI, my lord, page number 164, clause number.
Clause.
Clause number 11, my lord. Page 166 is the relevant clause. Lordship, what, page number 166, clause 11, my lord. 11, 1, 2, 3.
Yes.
Now, pursuant to this, but we had invested, raised concern, and also an agreement has been entered between the parties, my lord. The lordship may come to page number 88, agreement is entered.
This LOI is dated?
My lord, LOI is dated 19/5/2017. 19/5/2017. 17, my lord, 2017. 19/5/2017. Pursuant to which we invested money, we have constructed footover between 7 locations. Okay.
And thereafter, an
An agreement is also entered.
Hmm.
Agreement has been entered. Agreement is at page number 88.
Then,
My lord, this agreement is dated 5th October 2017, my lord.
so which agreement, which clause says LOI is part of
My
agreement?
lord, your lordship would notice page number 89, my lord. Clause 6. It says, last line, it's a LOI is a contract is entered pursuant to LOI. Your lordship, what was
Subsequently, grantor has issued a letter of intent.
the last sentence, my lord? While letter dated 18th so and so, subsequently the grantor has issued letter of intent SC number so and so dated 19/5/2017 letter of intent or LOI attached hereto as appendix 1 to the preferred bidder, appendix 1. Then your lordship may come to page number 94, my lord. 12(1)(a). Appendices to this agreement form an integral part of this agreement and will be in full force and effect as though they were expressly set out in the body of this agreement. So, my lord, MR engineer's judgment will once been bodily set up, Supreme Court. It is part of the clause. Then, my lord, your lordship may come to page number 97.
So what is the objection? You should file a civil suit. They want to pay you more interest.
In fact, I filed a section 9. I filed a section 9, my lord. Section 9, they contested. I lost the section 9. I did not get interim relief. I filed a CMA, it's pending. There they never raised an objection about maintenance.
Yes, what is the objection?
My lord, page number 155.
No, what is the page? Forget
Dispute resolution, my lord. As per the agreement, it's only negotiation, my lord. There is no arbitration clause.
No arbitration?
No arbitration clause. For amendment, my lord, page 1.
That's what the curiosity was. Yes. So where is the arbitration clause now? He says that there is no arbitration clause.
I'm saying the LOI because part of the contract. LOI contains arbitration clause.
Yes.
No, my lord, page number.
And, my lord, today government is emphasizing to go to arbitration. They issued a GO also, government. And today now, they never object to in section 9. They contest section 9.
We don't know.
Same objection for is in section 9. For a moment, page
No,
1.
no, no. So you say that there is no arbitration clause, right?
Dispute resolution has been defined in page 155. In the same agreement, your lordship may take 155 for a moment. Article 16, dispute resolution.
Your public body, right? Like you playing with public money, right? If he succeeds, the civil suit will be decided in 15 years. You want to just for technical this thing. What, Mr. You should advise your clients properly, and probably you are too young to advise your client. So therefore, they will not hear you, obviously.
But page 155 for a moment. Right? The negotiation, Article 16, dispute resolution. The parties shall use their respective reasonable endeavors to settle any dispute merit. It is through negotiation. And page number 90.
So, supposing if your officers do not agree, it can never be settled according to you. He also cannot file a suit. He cannot invoke arbitration. He has to run after your officers all the time.
Right, they violated the terms of the agreement, my lord. The display.
You understand. This is part of the agreement.
Yes, but then
we will record that you have vehemently argued that
it is
misconceived and it should be dismissed with costs.
Also we will write. And Article 1.3, my lord, for a moment 98, my lord, priority of the documents. This authorization agreement shall be treated as a priority document, and my senior is relying on LOI, my lord, that is the third priority document, my lord, from the
No, it may be whatever priority, Mr. It may be last priority document. The question is, if it forms integral part of the agreement, what should be? You don't want, right? It should go to an arbitrator. Why?
For a reason.
I mean, you are a
yes, there is lapse of an arbitral clause, my lord. That is the only issue. Arbitration clause is not mentioned, and the dispute resolution clearly it states negotiations.
You take the matter to Supreme Court, right? In this before they exhaust all the remedies like this. They want to pay you more interest, right? Nothing else. What, Mr. We really fail to understand. Such an unreasonable stand. I mean, that's why I said you are too young to advise your clients to settle this matter. They would not listen to you. Therefore, you are under an obligation to contest it tooth and nail where there is nothing. Yes, Mr. Anything else?
Well, your lordship posed a query. What is their objection for arbitration? Unless there is some kind of prejudice is there. LOI, they are admitting it. LOI being a part of the agreement, they are admitting it. Only saying that negotiations. The negotiations have failed. Thereafter, we have filed a writ petition, writ appeals, everything has been done. Section 9 is filed, never raised this objection. Section 9 has been
raised, even in the counters we have raised. Same objections were raised.
They did not carry the matter for appeal. So therefore, my lord, Section 9 has been done. I have invoked arbitration. And today there is nothing which says that LOI is not binding on them.
What is the quantum like?
Well, it's only interpretation of the period, my lord.
No, what is the quantum of the amount?
Around 2.
Oh. Yes.
Maybe a district judge or a senior councilman, anyone.
We'll appoint a former judge.
So the common when all the 7 matters same, so that.
Yes.
Who is in the panel, man? Former judge of this court, A.
Santosh Reddy. Former judge, we were.
Lordship may A. Santosh Reddy, Justice A. Santosh Reddy. Subject to my friends.
Well, statutory body has also its choices, right?
As a last choice. As a last choice, right?
You want to. We are aware that you are so keen to settle with negotiation, right? But Mr. This is disgusting, really. A stand taken by the government to promote alternative dispute resolution, and this is really something disturbing that the public authorities oppose the prayer here. I mean, is it not in the interest of your institution to resolve all the disputes quickly and to get ahead with your constituted to indulge in litigation, right? And to generate more litigation.
There is no arbitral dispute. Their stand is that there is no arbitral dispute involved. In fact, complying with the agreement.
Under the agreement, if he is claiming some amount on account of breach, you will say no arbitral.
Today they have come up with amount. They want extension of the authorization period was the earlier prayers. Even in this case, they have not mentioned about the amounts. Now they are coming up with a prayer The main prayer is for extension of, in this case, my lord, it's for appointment of arbitrator. But
Whatever objections section 16 permits, you take.
very good. Leave it, your lordship.
But it's surprising that you should come up. He didn't say anything.
Extension.
That an individual is understandable that he may have a preference for a judge. Institution also has a preference. You are a statutory body, right?
Yes.
Who are you?
THNC, that's
Then
Greater Hyderabad.
you also have a preference. He didn't say anything.
Right.
He said, all right, whatever court feels. How are you concerned?
No, my lord. In fact, my colleague has just suggested the name, my lord. If at all we are going for appointment, then Justice A. Santosh Reddy.
And this court cannot appoint anybody. Should
No,
we record your submission?
No, my lord.
Should we record?
That is the reason I requested for a suggestion, man. Suggestion of the names. But I apologize.
Don't do, mister. It's all. This only speaks about the conduct of your officers, how they behave.
I apologize.
Nothing else.
I leave it to your lordship.
Yes. 20.
Third week
You
of
will be
December.
busy in elections,
Election.
right? Huh?
Commissioner is held up in election, but he need to.
Commissioner needs to appear.
Yes, ma'am. Commissioner, additional commissioner and commissioner.
No,
Additional
no, no.
commissioner
Who
is
will appear before
additional
the
commissioner.
arbitrator?
Additional commissioner.
Then you will be busy counting votes. Huh? He's a returning officer. What you to do with election?
They are held up in the election duties, my lord, as they inform.
You are returning officer. That's what busy counting. What or protecting ballot boxes? What will you do? We listed before that 25th November.
Okay.
Accordingly, the petitions are allowed. Yes. Common order also. In this petition, then plural this thing, right? Whatever that you do. Up to 238.
Take, man.
Yes.
My lord, in this matter, I need to file a reply, my lord. Last week one, in this matter, I need to file a reply, my lord, for the applicant.
Reply.
My lord, I need to do some research also, my lord, because they have raised an issue of maintainability. Lordship, I kind.
You didn't anticipate, right?
My lord,
17 November.
any day, my lord.
Learned counsel for the
Lordship,
petition.
accommodate me for 2 weeks, my lord, because 3 issues they have raised, my lord. 3 I have to research and come back to your lordship.
That's the issue, sir. Non-payment of stamp duty. But that's covered by the larger bench.
Locus, my lord, my partner given me.
Yes, so then what is Mr. You just now we have 2023 volume 7 SCC
Yes,
page 1.
Lord,
What like
insofar as
what will you do in these 3 days?
Lord,
What will you do tomorrow, day after, and Monday? You can make a research.
insofar
Let's pray. Please don't seek an adjournment.
No, Lord, I will not.
Yes.
May I please?
Yes.
I appear for the applicant. Because I am also facing a similar issue, although no objection is taken in the counter affidavit. And also I realized that the agreement is stampable with 200 rupees, but it has been stamped with 100 rupees. So I'll have to take steps for impounding it. Your lordship may give me 2 weeks, my lords. I'll get it impounded and I'll file the impounded document before your lordships, because the originals, my lords, have been filed in a section 9 application. Lordship may give me 2 weeks time. I'll file the impounded document along with the original for your lordship's kind consideration. 2 weeks.
Learned counsel for the petitioner.
Objection.
The other objection, I will answer your
That's another objection I raised.
We will answer. We will hear nothing. It's being adjourned present.
With regard to the maintainability, I raised another objection.
Learned. Whatever.
Very well. As your lordship.
240, 241. Next 24th November, Mr. 24th November.
Please, my lordship.
Yes.
I filed by impounded your lordships. Lordship may have it next week.
Why? You have filed already, right? So the burden, he is not seeking time. He should seek time, ideally. What is it, Mr.? Agreement is admitted. Arbitration clause is there.
Yes, my lord.
Let
Maintainability and my
what maintainable? What? How it is not maintainable? Tell us at least. How?
Lordship may have it next week.
You don't know. Maintain.
I
See, Mr. Now, one thing, you are a youngster, that's why I am telling you, maintainability connotes a statutory bar. There is no law which prohibits petitioner from filing a petition under section 11(6). It's one thing to say that the application at the instance of the petitioner should not be entertained, or we don't know whether which law says that he can't file it, then the maintainability aspect would arise. That's why we ask what is maintainable, not maintainable. Why?
get instructions also your lordship from the client's will.
After filing counter, you are seeking instruction again. What will client think? Huh? We are adjourning, Mr. But tell your colleague what like he has just now said that I have filed counter and then again praying for time. This on 17.
My apologies, Your Lordship. I'll be there.
1711.
I'll be there, Your Lordship.
Applicants, my lord, counter is already filed. Counter is already filed, my lords. I'm appearing for the applicant.
I am appearing for this.
Oh, yes.
Yes.
What?
And though we filed a counter that there is no basis in the claim, my lords, I'll read to your lordship.
What is this thing quantum of?
Arbitrary.
1.5 crore, my lords.
11.6 so and so, clause so and so provides dispute as a reason. Where is that? That corporation was saying, no? Which name of judge? Yes.
Justice Kodanram.
No.
In the previous
No,
matter.
not. Former judge, the corporation council was saying, Justice A. Santosh Reddy, former judge. You will appear when?
I'll leave it here. First week of December.
Yes, first week of December.
You are not concerned with elections, right?
My clients are outstation, that's why they're not.
You are not concerned with the elections, right?
No.
In one case, we are asking because one case we were told that we will have 12/20/23 allowed.
Right.
Yes.
May please, Lord. Lord, in this matter, my lord, this is regarding a construction of a 400 kilometers road in on the Arunachal Pradesh.
They have served, right? They have been served.
We have also filed counter.
Counter. What to do?
We are opposing it on 5 grounds. One important ground is that parties who are not parties to the agreement also.
You are an outstation council, right?
My learned friend is outstation.
Oh.
I'm sorry.
What to do? You should have mentioned that like 4 o'clock when we would have taken this matter.
I'm sorry, my lord.
So all right, we will hear 1 minute. Let me finish. We'll take up then.
Yes.
Will it take time?
It will take time.
Oh. So when can you come next?
Lord,
And on that day, please mention. Please mention. We will take up.
I'm highly obliged. Lord, 1st of December.
1st December. On account of paucity of time, the matter could not. Yes.
The application is filed for substitution of the Honorable Judge Millard. Unfortunately, the Honorable Judge who was appointed as arbitrator was expired.
Oh.
Justice A. Gopal.
I am appearing for the respondent, my lord.
Yes. So this we have to appoint another arbitrator. Can you? Yes. So can you give an agreed this thing name?
I leave to Lordship. Any time.
Yes, Mr. Any former judge of this court?
My lord, I leave to lord. Lord,
Yes.
I leave it to lord.
Oh. All right. No former judge. You're not High Court judge. Justice, we have appointed recently Justice Rajshekhar Reddy. So you're right, Justice A. Rajshekhar Reddy, former judge of this court. Yes. Yes. Next.
Yes, sir.
So file by next date, madam, we will take it up on 17th. Learned Counsel for Respondent Place. Yes.
But, I'm appearing for the response. Leave and license agreement for cultivation of
cardamom. Oh.
fact, I am
Oh,
opposing.
they are opposing, right?
So they are opposing from the beginning, but I am.
Beginning, but today probably is not the ideal.
It's convenient.
17th November.
24th, if your lordship can. 17th, I am. This is, my lord, 24th, I can only say, for a long time it is getting.
Long time.
There is a division bench order which they are not complying also. Right? We have filed contempt case, that's another matter. But
that
they are
will be dealt with.
not paying license fee, my lord, still
17th,
continue.
Mr.
Also,
Please,
my friend, his objective.
Today, list on 17th.
Their instance only it was getting adjourned.
No, we will decide it positively. Next year.
For the applicant, your lordship, requesting 2 weeks, your lordship, the representative for the company has been replaced. Representative for the company has been replaced, your lordship. For that extent, we are filing an IA. Requesting 2 weeks of time, your lordship.
Praise for adjournment list on 24th November.
Published.
For the petitioner, I request time for filing a reply, my lord. We filed counter today.
Learned counsel for petitioner praise for is granted a week's time. 20th.
Okay.
My lords, and for the applicant, they are ready for, they have raised 2 objections, my lords, and I am ready, those 2 objections will not sustain.
Lord, my objection is this application is very premature because the dispute what was raised in the notice dated 14/8/2023 is not.
1 minute. So he will. So you ready?
Yes, my lords.
Ready? Okay. Yes. Which case item?
My lord, page 32 is the arbitration clause.
1 minute. Page
32, my lords. It is a developmental agreement, a registered developmental agreement. From page 26, the developmental agreement starts, my lords, and page 32, clause 18 is the relevant clause.
What is the date? Date of agreement.
The date of agreement, my lords, 25th October 2018.
Yes. So
page 32, my lords, the relevant clause is clause 18.
18.
Well, one of the, what the objection they have raised is that the number of arbitrators are 2. Which is hit by the section 10 because the section 10 says it should be only the odd number. But by law, there are Supreme Court judgment in this regard. But it said whenever the number of arbitrators are even, the court can always appoint the sole arbitrator. Those judgments, my lords, MMTC Limited versus Sterlite Industries.
Citation.
Yes, my lords.
My lord, I have my.
1 minute. What? We will hear you, madam. It can't be decided without hearing. He is the petitioner. So therefore, he.
My lords, the item number 3, the serial number 3, MMTC Limited versus Sterlite Industries. Page 26, paragraph 9 and 10, the relevant paragraphs.
Hey, Mr. This what like Manu Patra citations? You don't subscribe to SCC?
My lords, I am not very conversant with the SCC online. It's my.
What is like this free copy downloading site, right?
No, my lords, Manu Patra is a paid subscription.
No, what? We don't. You give us this SCC citation.
Equivalent SCC citations I will submit, my lords.
So when will you submit? The order is being passed. We will be passed right away. I am not going to reserve this and for pronouncement of judgment.
But even the Manu Patra is a paid subscription.
No. Maybe paid subscription, but we don't use Manu Patra, right? No, there's no apology, but you are expected to give either AIR or whatever.
I will try to upgrade myself to the.
See, 1996 volume 6 SCC 716. It's written at the top itself.
Page 26. Equivalent citations.
Equivalent. You should have told that this is the citation.
I'm not aware of that, my lords. Equivalent
you have filed. You are not aware. Somebody has filed.
No, my lords. I'm conversant with the Manu citation, but not looking into the equivalent citations. I admit my incapacity.
No question of it. It's not an incapacity, just inadvertence. You could have, if you would have seen, you would have found out. Yes, okay.
Yes, my lords. The para 9 and 10, page 26. The relevant paras, my lords, very quickly.
Para 9 and 10.
Yes, my lord. Subsection 3 of section 7 requires an arbitration agreement to be in writing, and subsection 4 describes the kind of that writing. There is nothing in section 7 indicate the requirement of the number of arbitrators as a part of arbitration agreement. Because the validity of an arbitration agreement does not depend on the number of arbitrators specified therein. The number of arbitrators is dealt with separately in section 10, which is part of machinery provision for the working of the arbitration agreement. It is therefore clear that the arbitration agreement specifying an even number of arbitrators cannot be ground to render the
We have read
invalid.
it can't be a ground. Yes, to
Render invalid, my lords. So the page 32 is my arbitration clause. And according to the agreement, my lords, they are supposed
You said two objections. So one is even number of arbitrator and what is
Second thing, they are saying that I have filed under the wrong provision, section 11.5, read with 11.6. Mere mentioning of a wrong provision of a statute will not even render the application to be an invalid, my lords.
Invalid.
Mention the relevant paragraph. The P.K. Palaniswamy and Armugam and others versus N. Armugam and others, page 7, paragraph 13. And my lords, they have filed a section 9 application in the city civil court in the 9th ACJ. In the last hearing, my lords have asked, just because they filed a section 9 application, does it mandate them to agree for the arbitration? I have mentioned 3 citations in this regard, my lords.
No, not mandate means not necessary. Mandate means what? Like you are
itself invokes a section.
One minute. So therefore it's like a estoppel by conduct that they themselves this thing said. I mean, realize the arbitration like there is an arbitration agreement and then invoked section 9. Therefore, it is like estoppel by conduct.
Yes, my lords.
Not mandatory, nothing. It's like estoppel by conduct.
They cannot approve on the same thing.
I approve it. Yes.
The doctrine of attribute and retribute comes in hitting them, my lords.
Yes.
So my lords have asked the citations and I have mentioned the citations in that regard, my lords. And the 6th and 7th citations, my lords, specifically it mandates whenever
what you should do, how you can make it is better is that in this memo you have this thing you should write the proposition also.
My lords, I will improve it, my lord.
You should do it next time onwards. That
Yes, my lords.
proposition and then this case law along with the SSC citation.
Yes, my lords. I will do that.
Yes, madam.
Lord, we have filed a counter and our objection was regarding the notice of dispute. We do agree with the arbitration clause that exists in the arbitration clause, but that condition precedent for referring to the arbitration is a dispute. As per the notice given on 14/8/2023, which is a list of documents in this A2, my lord, exhibit A2, they have mentioned that the dispute is the respondents have not completed the work as per the agreement in a given period of time. In fact, my lord, kindly I would request my lord to look into the development agreement clause number 6, my lord, in page number 30. My lord,
You are admitting, madam, you are admitting existence of an arbitration agreement, arbitration clause, then why it should not be referred?
because it's not dispute as alleged by the plaintiff in this case, petitioner. There is no dispute at all. It is premature
That
stage.
you can demonstrate under section 16 before the arbitrator. All objections.
I oblige my lord.
Except the fact that we have to only examine whether it is barred by limitation. That is not your case.
My lord, that there is no dispute at all, my lord. There is even.
Very good. So give his money, give his, settle his claim, whatever is amounting.
My lord,
No dispute.
the petitioner can't take advantage of his own doing, my lord. He has already sold 22 plots out of 50 plots and now the last sale was in November 2022. Now newly they have come up saying that they have not completed the project. Had we not completed the project, the sale of 22 plots would have not taken place at all.
That we can't decide, madam, in a 11-6 petition. What is the scope? What is the scope of the petition? Please tell us existence of an
Stage. Referring to the arbitration, my lord, as there is no existence of dispute at all.
Only one rebuttal, my lord. Page 55, we have clearly invoked the arbitration.
What is notice dated?
Not.
Just a minute, my lords.
14.
Notice dated 19/6/2023.
She is saying no claim made by.
My lords, I am the landowner. They are the developer. They are supposed to develop the land according to.
No, whatever. What you have heard her saying, right? The argument is there is no dispute.
My lords, when I have issued legal notice, they have issued a reply notice in which they also has admitted that there is a dispute and I am supposed to pay certain amount.
Reply
notice dated 3/7/2023.
So they say that there is no dispute, right?
Yes.
My lords, please see page 59. They themselves says until unless you do not fulfill certain conditions, we cannot continue with the work. When there is a disagreement between the landowner, one party and other party, I put a question to myself, if that doesn't amount to dispute. What amounts to dispute, I do not know, my lords. At least I have to plead once again ignorance on that.
My lord,
I propose one thing.
Oh, you said ignorance. We thought that once again I will have to obtain BLLB degree.
That will be insult to my teachers, my lords. At least I will not say that.
Lighter.
That will be greatest insult to my teachers if I say that.
Don't take everything so seriously, right? At 450. Huh? You said that.
It's a learning experience, my lords.
Every learning experience every day. Whosoever is associated with law, he has to learn till he practices law. Everybody, all of us are students of law only. Right?
Yes, my lords.
This petition under section 11 within bracket 6
Even we are ready for.
This court doesn't have to appear, right? You should ask your friend when she can appear.
2nd December, we are fine with. My lord.
2nd December 20th.
My lord, humble submission kindly, my lord. My lord, all our objections, including the existence of this dispute and all, shall be recorded with the arbitrator, my lord. Raised.
It doesn't.
Section 16 empowers them the competency, competency they can rise there, my lords. Nothing stops them.
But it shall,
Nothing stops them.
be recorded, my lord.
Why are you arguing after the order has been passed?
Shall be recorded, my lord.
You should be happy, right? You are arguing. She should say something which she is doing. Why should you intervene and argue?
Sorry.
Yes.
My lord, this.
No, it's all. It goes without saying, man.
Yes.
Yes.
May I please?
Item.
Publishment.
We have issued personal notice to the respondents, my lords, and filed a proof of service on 16 and 2020.
You have filed
Proof of service.
17/11. It's court time is over. That's why nobody is appearing. Right? 17/11/20. On account of paucity of time, a learned counsel for the petitioner submits that proof of service. Yes.
Lordship, I'm appearing on behalf of respondents, my lordship. We have objection to this arbitration application and requesting 2 weeks time to file counter, my lordship. This application is barred by limitation, my lordship.
Let them file counter. It's on 24/11.
Much obliged.
Obliged.
Respondent.
17/11. List on 17/11. None for the petitioner. Mark his presence. List on 17/11/23. Yes.
This permission of the Honorable Court, learned arbitrator appointed by this Honorable Court had recused subject to.
Yes.
Just a substitution order is required.
And for respondent 1 and
So any other name with consent, madam? Any other former judge?
Justice K.C. Banu, sir? I don't know. I have to ask him.
Any recent appointed, madam, sir? Justice Praveen Kumar, Honorable Chief Justice, he was former acting Chief Justice of Andhra Pradesh High Court. Justice Praveen Kumar, or alternatively Justice Venkateshwar Reddy.
Or Justice K.C. Banu is who I.
Venkateshwar Reddy. Yes. Yes, madam. Mr. Venkateshwar Reddy. Yes. Consent of the party so and so in place.